This is Wednesday, July 20th, 2022. I am Judge Martin. This is courtroom number 1. Today's docket involves only criminal matters. If your case is not a criminal case, you are in the wrong courtroom. You should check your notice. If you're not sure, you may send a chat or message to the court staff and they will help you get where you should be. Mary Ann, we have a few preliminary matters to dispose of. We have 220229 FY. This is State of Michigan versus Carlos Wells Cadell. This court has received information that a necessary witness for this preliminary examination that's scheduled at 12 o'clock today is unavailable due to medical issues. The exam that was scheduled in person at noon today will be adjourned to, I think, that August 17th. Do we have the 1:30 spot available, Mary Ann?
We have starting at 1 o'clock.
I
guess.
know, but I'm gonna,
Sorry, yes, 1:30 is open.
at 1:30. That gives the prosecutor's office time to relay that information to Mr. Bickert and the defendant in this matter. And then there are 210155 SM, State of Michigan versus Teal Black scheduled for pretrial, and 210443 FY, State of Michigan versus Teal Black scheduled for exam this afternoon at 1 p.m. This court has received a stipulation from the parties indicating that defense counsel is unavailable and out of state and will not return until July the 25th. The stip did not include a new date. Court called the case this morning to indicate that the adjourned date will be August the 17th at 1 p.m. That's back here live again in courtroom number 1.
Judge, I'm sorry, did you say August 17th at 1?
Yes, ma'am.
Thank you.
Thank you. Those preliminary matters having been disposed of, Mary Ann, is there anything ready to go?
Mr. Maynard just sent a message that he's requesting an adjournment. I don't see his client though. I'm sorry, his client is here.
This is 220478 FT, State of Michigan versus Cunningham. May I have your appearances, please?
Good morning, Your Honor. Attorney Jeffrey Maynard for Mr. Cunningham, who also appears on the Zoom.
Mr. Cunningham, state your name for me, please.
Cyrus Cunningham Jr.
Thank you. Did we just
Judge-
lose Ms. Bailey, or is she still here? I'm sorry, Mr. Maynard, the prosecutor is here. I'm just waiting for her to put her appearance on.
No problem, Judge.
Ms. Bailey? Mr. Maynard, have you been in communication with the prosecutor?
No, Your Honor, we were just retained. You should have a substitution that was sent over the last couple of days.
I have it.
Very good.
The basis for your request for adjournment, sir?
Your Honor, we did have discovery forwarded to us by the court-appointed counsel. I have reviewed the paper discovery. There is a number of videos. I need an opportunity to review those and speak to the client. So we'd like to waive the 21 days and adjourn the PCC out maybe 2 weeks.
2 weeks out will give us what date, Mary Ann?
August 3rd at 9:30.
And that's in
And that-
courtroom number 2. I'm sorry, Mr. Maynard, you were asking a question.
I was just saying that was not a problem, Judge.
Okay. August 3rd, 2022 at 9:30 a.m. in number 2 with Judge Oakley. Anything else, Mr. Maynard?
Your Honor, will that be in person or do you know?
Back by Zoom.
Okay, very good.
Thank you, sir.
Thanks so
good
much.
day.
Everybody have a great day.
Mr. Parker, I thought I saw, good morning, sir.
Good morning. How are you?
How are you, sir?
Good. I
There,
have,
Mr. Moss is here. Do you need to speak to him or are you ready to proceed?
we're ready to proceed. I've just talked to him yesterday. We're good to go.
This is 220504 FY. This is State of Michigan versus Nathan Gregory Moss. May I have your appearances, please?
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
Good morning. NDS Detroit by James Parker on behalf of my client, Mr. Moss, P53832.
Mr. Moss, state your name for the record, sir.
Nathan Gregory Moss.
Thank you. Today is the day and time set for the PCC in this matter. Mr. Parker, how are we proceeding?
Your Honor, could we have an adjourned PCC date? I do not have any discovery or anything about this case discussed with my client.
How long of an adjournment are you looking for, sir?
Can we have at least 3 weeks, please?
3 weeks will put us on
August 10th at 9:45 with Judge Green.
That'll be
I'm sorry,
fine.
at what time?
9:45.
Thank you, Mary Ann. I'm sorry, I just missed the time. This PCC is adjourned to August 10th, 2022 at 9:45 a.m. in number 3 with Judge Green. Anything else in this matter, Mr. Parker?
I have nothing else at this time, Your Honor.
Anything else, Ms. Mosisian?
Nope. Mr. Parker, you'll have discovery by the end of this week. Thank you.
Thank you very much.
Thank you. Mr. Moss, August 10th with Judge Green. Have a good day, sir.
Thank you, Your Honor. You too.
We're finished, Mr. Moss. You can leave and I'll call you.
Thank you, Mr. Parker.
Your Honor, ma'am and Madam Clerk,
Yes.
this is Deputy Pravachi. Good morning. They just handed me 2 add-ons for warrants, and I want to know if they're assigned to you. A Michael Cohen. These are both warrants. Michael Cohen and a Carlton Brown.
That's a Ramus. I'm not sure who,
Because they had
I'm
on
not
the
sure
paper
who's
I got.
scheduled with the Ramus this morning. I'm sorry.
Is that Magistrate Hinman or Judge Hinman?
Not Judge.
It is.
Okay, thank you so much.
You're so very welcome.
And we still have Jerome Curtis for you.
Mr. Curtis's attorney is
Judge, that's kind of like a
from
little
NDS.
a snafu this morning. I was never notified. Some of the NDS attorneys, I don't know their names because they weren't given to me.
I see
I
an
don't know.
NDS intern here. Let's see if we can get some guidance and assistance from them. And there's Miss Mai Shine.
Hi, Judge. Who are we looking for?
Mr. Curtis, Mr. Jerome Curtis is down at Division 1, and that's who's on the screen right now. Our notes just say NDS.
One moment, please.
Thank you.
Of course. That would appear to be Nancy Richards. I will text her immediately and let her know you guys are looking for her and that her client is on Zoom ready to go.
Thank you, ma'am.
Absolutely. Anybody else you need?
Mr.
Yes, if you
Marks,
don't-
do we
can
know
I
who he's
interrupt?
connected with?
Can I answer that question?
One more time?
I have a few. Do you mind, Miss
Sure,
Michelle?
sure, sure.
Absolutely, ma'am.
Thank you, Judge. There's Tyler Miller.
Hang on one second. Let's see. Changing screens, toggling, sorry. Miller, Tyler, you said. That's Nancy as well.
Okay, maybe I should chat these to you so the judge can continue.
All good.
All right, thanks.
Miss Maisha, I think Miss James is your client. She's not scheduled until 10 o'clock, but she's here. And I
And
just
we're
saw
here
them put
for
her in
her,
a
Judge.
breakout
And so
room.
we're just going to demand that preliminary examination. And that is why the intern is here. If the court would be gracious enough to allow our intern a moment of experience on a record. You remember when that was exciting too, right? So
It
Ms.
still is
James
exciting,
is
ma'am.
aware. We would just appreciate it if you allow him to do so. Under,
soon
of
as
course,
she's-
my close supervision.
Motion granted. She's
Thank
in, Ms. James is in the clerk's waiting room. As soon as they verify her information, they'll put her back in the main session. I'll call the case and we'll have your intern proceed.
Thank you so much, Judge.
Thank you, Your Honor.
You're so welcome. Good morning, Ms. Richards. Do you need to speak to Mr. Curtis?
Yes, please.
Marianne, I'll get you moved into a breakout room.
Thank you.
Good morning.
Good morning. This is 220490FY. This is State of Michigan versus Raina James. May I have your appearances, please?
Yes, ma'am. Good morning. This is Raina James.
Morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Morning, Your Honor. Jack Canarak on behalf of Miss Raina James. I'm an intern with Neighborhood Defender Service under the supervision of attorney Kim Michon, requesting permission to practice under Michigan Court Rule 8.120.
Request granted. Today is the day and time set for the PCC in this matter. How are we proceeding, sir?
Your Honor, on behalf of Ms. James, we have received full discovery in the matter, so we are demanding an in-person preliminary examination.
That live exam date will be
August 10th at 12:30.
August 10th, 2022 at 12:30 p.m.
Judge, regrettably, Kim Michon, on behalf of Ms. James, I'm actually on vacation that very week for the first time since the pandemic. May I graciously ask for another date, please, and thank you.
Absolutely. Let's try again.
August 17th at 2 o'clock. Will you be back?
I will, but I will be starting a jury trial. Is the 24th available or the 3rd?
The 24th at 1 o'clock.
My hero. Thank you so very much. I do appreciate the flexibility.
We will see you back here August 24th, 2022 at 1 p.m. live in courtroom number 1. There's indication on the record that discovery has been received. Anything else on behalf of your client, sir?
No, Your Honor. Thank you.
Thank you so much.
Well
Anything
done.
else in this matter, Madam Prosecutor?
No, Your Honor, nothing further from the people.
Thank you. Ms. James, I will see you here in courtroom number 1 on August 24th at 1 p.m. Have a good afternoon.
Thank you.
Thank you so much, Judge. We appreciate your time and grace. Have a lovely day.
You too, ma'am. Thank you. Who is MIDC this morning?
Mr. Bowditch?
I see people hanging out in his meeting room. Oh. I thought I saw him.
He came in under, he's ANNES.
Okay, thank you.
Yep.
Mr. Ortiz, have you spoken to your attorney this morning?
Just briefly, he just,
Okay.
he reminded me of the time. He said 8:30, and I thought it was 8:45.
It is 8:45. As soon as your attorney gets here, we'll get your case call, get you on your way, sir.
Okay, thank you.
You're welcome. Thank you for your help, Officer Ramsey. Good morning, Mr. Bowditch.
Your Honor, I
Yes,
apologize.
sir.
My reputation is being early. I apologize for being late today, but I got a text yesterday that told us MIDC lawyers not to check in early. And they said Judge Martin starts at 9 o'clock. You don't check in, but I got here at 8:45 anyway. Your Honor, I apologize, and the hell with them. I'm just going to start checking in early.
Don't apologize, sir. We're fine.
Well,
Did you have something that was ready?
no, Your Honor. I guess is Miss Bailey the prosecutor? I guess I need to speak with her.
She is.
Maybe she got the same text I did.
No, she's here. She's been here since just after 8:15. You should be able to move yourself into her waiting room. I'm not sure where she is right now. Oh, she's here in the main session, sir.
Oh, okay. Well, when appropriate, Your Honor, I need to speak with Miss Bailey.
Understood. Miss Bailey?
Yes, ma'am.
Mr. Bowditch is waiting for you, please. Thank you. Attorney Hamilton?
Yes, Your Honor.
How are you this morning?
I'm good. How about you?
I am wonderful. Are you here for something specific?
Yes, I'm here for a PCC for Jamichael McCoy.
I don't know that we've seen Mr. McCoy. Oh, yep, he's in the clerk's waiting room, waiting for his information to be verified. When he's done, do you need to speak with him?
No, well, actually, yes, I'd like to speak with him. Possible.
Okay. When Heather's done with him, we'll make sure you get matched up and put into a breakout.
All right, thank you.
You're welcome. Ms. Richards, are we ready with Mr. Curtis?
Yes.
Miss Bailey, I think is in a breakout room. As soon as she, or Ms. Moisezian, is this your case?
Yep, this one's mine.
This is 220495FY. This is State of Michigan versus Jerome Curtis. May I have your appearances, please?
Good morning, Your Honor. Sonam Mofsissine on behalf of the people, P83923.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Curtis, who is present on Zoom at the Wayne County Jail.
Mr. Curtis, state your name for me, please.
Jerome Henry Curtis.
Thank you. I have a note on the file, Ms. Richards, before we begin, for the staff to get an updated address from Mr. Curtis. We have him on Ponderosa.
Your Honor, I believe that might be the location. I'm not certain if that's the location, the complainant.
Yeah, that is the complainant's address. That is not the defendant's address.
Your Honor, Mr. Curtis indicated to me that if he were to be released, he could stay with either of one of his siblings or his children, and he would not need to return to that location.
Before you leave, Ms. Richards, if you could chat that address to either Marianne or Heather. But before we get that far down, let's, today is the day and time set for the PCC in this matter. Ms. Richards, how are we proceeding?
Your Honor, at this time, I have not received any discovery. So I would be requesting another PCC, but given that Mr. Curtis is currently in custody, I would ask for that to be tendered to me as quickly as possible and a PCC next week.
Marianne, we'll see if there's space available on that 27th docket.
Thank you, Your Honor.
One opening at 9:45.
That would
Oh,
be.
no, he's in custody, so he'll be back on the 8:30.
8:30.
I'm sorry, July 27, 2022, 8:30 a.m. in number 2 with Chief Judge Bryant Oakley. Ms. Richards, I made a notation that discovery's been requested in this matter. Is there anything else on behalf of the people?
No, there is not. Thank you.
Anything else, Ms. Richards?
Your Honor, Mr. Curtis has asked that I address his bond. Bond is 10,010% currently. Obviously, Mr. Curtis has not been able to post that bond. He indicates that he would have no one who could post that bond for him. He indicated to me that he works for Modern Restoration and Truck Repair as a diesel mechanic. He was just getting ready to go back from work prior to his arrest. He has 6 children. He could live with his siblings or his children, and I will ask the court for another breakout room so I can get an actual address. He indicates to me that he has never been in trouble ever before. This is his first time ever coming to court. The most he's ever had previously is a speeding ticket. We are asking the court to consider a personal bond. Mr. Curtis will obey any no contact order that the court sets. Even if the court would feel more comfortable, a tether would also be something that we could ask for.
Madam Prosecutor.
Judge, if you're inclined to reduce his bond, we would request a tether. And the only reason I say that, I recognize that the defendant may have limited means, given the fact that initially he stated that he didn't have another address to go to. So I'm not sure if the tether would be feasible. However, that would be our request, because initially when the police arrived, this incident kind of happened in two waves, so to speak. They came, they told the defendant to leave. He indicated he would, and then about less than half hour later, he came back, and that's when the assault occurred. So I guess for the people's standpoint, we do have a concern of whether or not Mr. Curtis would obey, I guess, any no contact order, and that's why the GPS tether might be a little bit more reliable. But Ms. Richards is correct. I don't see any other felony encounters with this court. They were all license related.
Thank you, ma'am. The original bond was 10,000, 10% with a GPS tether if the defendant were able to post a 10,000. Based on the comments just made by the prosecutor, the court will grant defense motion to amend bond to 10,000 personal with that GPS tether requirement.
Thank you, Your Honor.
Anything else, Ms. Richards?
No, Your Honor, but if I could have another breakout room with Mr. Curtis just to get that address.
Absolutely. Thank you so much.
Thank
And we'll
you.
get that bond modification completed and transferred down to the jail.
Thank you very much, Your Honor.
Thank you, Your Honor.
You're welcome. Thank you, sir.
Thank you.
Are we, Mr. Bowdish, were you with Mr. Henry?
Yes, Your Honor, we're ready on John Henry.
Thank you. This is 22D221799SM. This is State of Michigan versus John Joseph Henry V. May I have your appearances, please?
No, Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Henry. Mr. Henry, could you state your name for the record, please?
My name is John Joseph Henry V.
Your Honor, we have had a chance to pre-try this case. Mr. Henry wishes to plead guilty to an added count of allowing an unlicensed driver to drive his vehicle, with the understanding the original charge, having a four-wheeler on a dirt road, would be dismissed.
Mr. Henry, raise your right hand for me, sir. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may put your hand down. Sir, you had the opportunity to speak to Mr. Bowdish this morning regarding a plea of guilty to the added count of allowing an unlicensed driver to drive.
Yes.
You understand that if the court accepts your plea this morning, you will not have a trial of any kind.
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes.
And you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promise anything to get you to plead guilty to the added count of allowing an unlicensed driver to drive?
Can you say that one more time?
I said you haven't been threatened in any way, promise anything to get you to plead guilty to the added count of allowing an unlicensed driver to drive?
I'm not getting all that.
Have you been threatened in any way, promise anything to get you to plead guilty this morning?
Oh, no.
Sir, is it true that on May 7, 2022, the Department of Natural Resources found you in Sumter Township allowing an unlicensed driver to drive?
Mm-hmm.
Yes or no, sir?
Yes.
Thank you. It's just not clear on the record.
I'm sorry.
Satisfied, Mr. Bowditch?
I'm satisfied, Your Honor.
Mr. Henry, the court accepts your plea of guilty to the added count of allowing an unlicensed driver to drive. The original charge of operating on a off-road vehicle on the highway or right-of-way is in fact dismissed. Sir, the court will impose minimum fines and costs in this matter. That will be a fine of $100, cost of $100. There's $75 mandatory crime victims fee, $50 show cost, $50 mandatory state cost, $20 fund fee, sir. That's $395. Are you able to pay that within 5 days?
Yeah.
Yes?
Yes.
Thank you. Sir, you can pay it online, you can bring it to the court, or you can mail it to the court. Anything else in this matter, Mr. Bowditch?
Nothing, Your Honor.
We are all set, Mr. Henry. $395 in 5 days, sir. Have a good day.
Thank you.
Thank you. Mr. Chambers.
Good morning, Judge.
Good morning, sir. I'm looking for your client. Mr. Wiley?
Yes, Your Honor. He's in custody, so I don't know if they've got him physically at Frank Murphy because he does have an AOI date this morning before Judge Bridget Hathaway. I'm about to call that court and see if they have him there physically. But he is being held in Division 2 in the Wayne County Jail.
Division 2 just logged on, and I'm not sure who this is on the screen as of yet.
That's not Mr. Wiley, but I don't know if they
Okay,
got.
if you want to go ahead and check with Judge Hathaway's courtroom, when you come back and give us an update.
Yes, I will.
Thank you so much. I saw Mr. Tylinda appear. This is 220441 FY. This is State of Michigan versus Charles Ortiz. May I have your appearances, please?
All right, for the record, Paul Tling on behalf of Mr. Ortiz, present in the Zoom room. We do consent to having this hearing done by Zoom. Your Honor, if I could have a breakout with the prosecutor on this case, if you please.
Yes, sir. Mr. Somberg.
Hello.
Hi, do you need to speak to your client this morning?
Yes, I just saw another attorney's name on him as well. Is that a typo?
I don't know
The
what
last
you're
attorney
referring
who
to, sir. I see your name next to his name.
Yeah, the last attorney who just spoke and asked to be put into a breakout room, it says that he was on Stephen Pingle as well on his.
No, he did
on,
not.
You know. Okay. It said it at the bottom, but okay. Yes. Yeah. Please put me in a breakout room. I appreciate it. Thank you.
Mr. Pingle, you should see an invitation to join your attorney in the breakout room 12. McCoy and Vanessa Hamilton into a breakout room.
Good morning, Judge.
Good morning, sir. How are you?
I'm great. How are you?
I'm super. Who is that with you in Division 2?
This is Joshua Yakes for probable cause.
I have not seen Mr. Washington yet this morning. Oh, no, there he is. He's connecting his audio. Mr. Washington, do you need to speak with Mr. Yakes?
Yes, Your Honor. Thank you. And good morning.
Good morning. Ms. Richards, were you ready on something?
No, Your Honor, if I could have a breakout room with Tyler Miller.
Judge, I'm sorry, Heather just called me. Am I supposed to, Miss Richards needs to
Ms.
go to?
Richards, yes,
Okay.
ma'am. Ms. Richards and Tyler Miller, please.
Actually, Your Honor, Ms. Mosivian just asked to speak to me about that case, but first, before I speak to my client.
I'll put you in her breakout room.
Okay, thank you.
Thank you, Mary Ann. Did Heather need something?
It's taken care of.
Thank you.
Mr. Strickland, what's your phone number?
734-334-7314.
If I get a chance, I'm gonna call you a little bit ahead of time, just make sure everything's what it should be.
Yes, sir.
We'll be with the judge in a second.
Yes, sir.
Are we ready, Mr. Washington?
Yes, Your Honor. Is it possible I can speak just briefly with Ms. Dornick?
Absolutely.
Thank you.
Are we ready now on Pingle?
There was no prosecutor in the breakout room. I was just placed with my client. So I came back here.
Well, Mr. Bowditch, are we ready on Strickland?
Yes, Your Honor.
This is 220506 SM. This is State of Michigan versus Jonathan Strickland. May I have your appearances, please?
Ready, Your Honor. For the record, Jeffrey Bowditch appearing on behalf of Mr. Strickland. Mr. Strickland, could you state your name on the record for the judge?
Yes, Jonathan Meyer Strickland.
Thank you, sir. Your Honor, today's a date and time set for a pretrial in this matter. We've had a chance, I've had a chance to talk to Mr. Strickland. We'd like to set this, Your Honor, for a final pretrial in which the complainant must appear.
Your Honor, Michael Kazak for the People, P 2114. I have no objection to setting a final pretrial date for the complaining witness.
Thanks, counsel.
I'm sorry, it was Mr. Kajak?
Yes, Kazak, yes.
I have Ms. Bailey's name. I just wanted to update our file. That final pretrial date will be
July 27th at 9:45.
July 27th at 9:45 a.m. That will be in number 2 with Chief Judge Brian Oakley with the notation that the complainant must appear. Anything else in this matter on behalf of the people?
No, thank you, Your Honor.
Anything else, Mr. Bowditch?
No, Your Honor. Thank you.
Thank you. Mr. Strickland, we'll see you back here on July the 27th. Have a good day, sir.
You as well, ma'am. Thank you.
Thank you, Mr. Strickland.
Thank you.
Thank you.
You get the officer to tell you how to get out of it, Mr. Strickland.
Okay.
No, we're not doing that on the record. This is 210940FY. This is State of Michigan versus Joshua Yakes. May I have your appearances, please?
Good morning, Your Honor. Elizabeth Dornick appearing on behalf of the people, P79420.
And good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Joshua Yakes.
Mr. Yakes, state your name for me, please, sir.
Joshua James Yakes.
Thank you. Today's the day and time set for the PCC in this matter. Mr. Washington, how are we proceeding?
Your Honor, I've had an opportunity to discuss this matter with Mr. Yakes. I've advised him that he does have a statutory right to have a preliminary examination, and Mr. Yakes is choosing to waive the exam.
And there's no objection from the people.
Mr. Yakes, raise your right hand for me, please. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You may put your hand down. Sir, you were able to hear Mr. Washington just now regarding your right to have a preliminary examination in this matter?
Yes.
You understand that at that examination, the people would have to show that both a crime was committed and that probable cause exists to believe that you were involved in the commission of that crime.
Yes.
And knowing that that's the standard, sir, you wish to waive your right to have that examination?
Yes.
And sir, you're doing this freely and voluntarily? You haven't been threatened in any way, promised anything to get you to waive this exam?
No.
And there is no objection from the people. Mr. Washington, inasmuch as you and your client appear by Zoom, there is not a signed waiver in the file. Do you give the court authority to sign the waiver on your behalf and on behalf of Mr. Yakes?
Yes, Your Honor.
Mr. Yakes, the court has now signed the waiver form. You will be bound over as previously charged. Your next court date will be an arraignment on the information that will be on July 27th, 2022 at 9 a.m. at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue. Anything else on behalf of the people?
No, thank you very much, Your Honor.
Anything else, Mr. Washington?
No, we have nothing else. Thank you very much, Your Honor.
Thank you. Mr. Yakes, good luck to you, sir. Have a good day.
Thank you, too.
All right.
Thank you.
Have a good day.
Your Honor, we're ready on Ortiz.
Mr. Tylinda,
Yes, Your Honor.
I was just about to call your client's case, but I'm going to ask a favor. When you appear in this courtroom, do not come into the main session and yell out like that, please. I see you and I see your client. I will call cases as they are scheduled. I appreciate your assistance, though.
Understood. Thank you, Your Honor.
This is a recall of 220441FY, State of Michigan versus Ortiz.
Your Honor, for the record, Paul Talenda, on behalf of Mr. Ortiz, we consent to having this hearing done by Zoom. Your Honor, we're asking the court to set up an exam date for this matter.
Mr. Ortiz, state your name for the record.
Mr. Ortiz, you have to turn your microphone on. We can't hear you.
Charles Paul Ortiz.
Thank you. And we don't have a prosecutor in here just right now. So Mr. Tylen, is discovery complete in this matter?
I have received videos, Your Honor. I believe that I have been tendered everything.
That exam date will be
August 10th at 12:30.
Your Honor, I'm set to be out of town. Coming back on, let's call it the 15th. Could we have something the week of that, of August 15th?
August 17th at 2 o'clock.
I've got an in-person in Oakland County. Is there earlier or later in the week? Or perhaps
Only on
earlier on Wednesday?
Wednesdays, sir.
Okay, can we do Wednesday morning?
No, sir. They're Wednesday afternoons.
Very good. How
Mary Ann
about,
will look for another day for you. Hold on a second.
August 24th at 1:30.
that's great. Thank you so much.
August 24th, 2022 at 1:30 PM, live here in number 1. Anything else, Mr. Thalinda?
That's all, Your Honor. Thank you so much.
Thank you. Have a good day, Mr. Ortiz. I'll see you next month, sir. Have a good afternoon.
Thank
Mr.
you.
Ortiz, we'll talk soon.
Okay, thank you.
Mr. Sonberg, did you get in with Ms. Bailey at some point?
I did, we spoke. I just, if you could put me in a breakout with my client so I can make sure he's okay with the resolution, and then we'll be ready.
Absolutely. Ms. Bailey,
Yes, ma'am.
Mr. Thalinda came back with Mr. Ortiz and demanded exam. It's set for August 24th at 1:30 PM, ma'am.
Okay, August 24th. At what time, Your Honor? I apologize.
That's no apologies, 1:30.
Thank you.
You're welcome. Mr. Bowditch, did you have something ready, sir?
I have a Denise Brown. She's on the phone, Your Honor. She's on a telephone connection. She moved and hasn't gotten her computer set up or anything yet. It's just an adjournment at a pretrial.
It looks like she's stuck in the meeting room.
I'm not sure on her phone how that happens, whether you can get out of a breakout room.
She's here now. It worked. This is 220477, excuse me, SM. This is State of Michigan versus Denise Brown. May I have your appearances, please?
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Ms. Brown. Ms. Brown, could you state your name for the record for the judge, please?
Yes, the name is Denise Lynn Brown.
Thank you. Mr. Bowditch, today is the day and time set for the arraignment and pretrial in this matter, sir. For purposes of arraignment, what say you?
We would waive formal reading, Your Honor, and stand mute. Your Honor, we'd like to adjourn this for a pretrial. Ms. Brown was wondering if it could be in person.
She has an absolute right to have that exam in person, sir. But before we get that date, there is a request from Van Buren Township that her bond be set at 2,010%. The court will set the bond at 2,000 personal. Ms. Brown, you do not need to post any money, but what you must do is appear as directed by this court and participate in these proceedings until they are resolved. Your live pretrial date will be
August 3rd at 9:30.
August
And I'm
3rd
sorry,
at
did you
9:30
say I have
a.m. and that's in number 2 with Chief Judge Brian Oakley.
Okay, okay, so that's August 3rd at 9:30?
Yes.
Okay, and did you say I have to come in and post a bond?
No, ma'am. I said the complete opposite. I said your bond is set at 2,000 personal. You do not need to post any money, but ma'am, but what you must do is appear as directed by the court and participate in the proceedings until this matter is resolved, okay?
Oh, of course. No, I understand. Yes.
Anything else, Mr. Bowditch?
Nothing, Your Honor.
Ms. Brown, have a good day. August 3rd at 9:30 with Judge Oakley.
Okay, thank you so much. I appreciate it, Your
You're
Honor.
so very welcome. Have a good day.
Okay, Mr. Bellick, are you still there?
Yes, ma'am.
Okay, so will you be my attorney when I appear on the 3rd?
Yes, ma'am.
Okay, wonderful. So I'll just speak to you then?
Yes, ma'am. It'll be my pleasure.
Okay, thank you so much. I appreciate all your help. Thank you.
Thank you, ma'am.
This is 2S4064849 A and B. These are State of Michigan versus Stephen Pingle. May I have your appearances, please?
Hi, Your Honor.
Good morning, Attorney Nicholas Somberg on behalf of Stephen Pingle, who is present by Zoom video.
State your name for me, please, sir.
Stephen Pingle.
Thank you. Today is the day and time set for your arraignment and pretrial. Mr. Somberg, what say you for the arraignment, sir?
Regarding arraignment, my client will stand mute. We'll wait for formal reading of the charges, Your Honor.
Thank you. There is nothing in the file regarding bond in this matter. Court will set his bond at 1,000 personal. Sir, you don't need to post any money, but what you must do is continue to appear and participate in these proceedings until the case is resolved. Mr. Somberg, you've had the opportunity to speak to the prosecutor in this matter. How are we proceeding for purposes of pretrial?
Thank you, Your Honor. Yes, we do have the case resolved today. They're going to be dismissing count 2, the misdemeanor. And I have the authority to enter a plea responsible to count 1 on my client's behalf, and we did make an agreement to a reduced fine at 50%.
Mr. Pingle, raise your right hand for me, please, sir. Do you swear from testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Sir, you understand that the court accepts your plea this morning. You will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes.
And you're entering this plea freely and voluntarily?
Yes, I am.
You haven't been threatened in any way, promised anything?
No.
Sir, is it true that on June 22nd, 2022, Michigan State Police found you to be in the city of Romulus County, Wayne, state of Michigan, with a vehicle that was overweight?
Yes.
Satisfied, Mr. Somberg?
I'm satisfied, Your Honor.
Based on the representations made by Mr. Somberg, the B file in this matter, which would the registration or plate violation, is dismissed in keeping with the plea reached by and between the parties. Mr. Pingle has tendered a plea of responsible to the overweight, which is the A file, with the understanding that the fine will be reduced. The fine as printed in this court's file is $3,780. That puts the reduced total fine at $1,890. Is my math accurate, Mr. Somberg?
That's not what we discussed with the prosecutor.
Oh, what did you discuss, sir?
I thought it was $400 fine.
No, I was, for Bailey on behalf of the people, Your Honor. I had discussed the reduction and the fine being half of what it would normally be for 2 axles overweight, which is $200. I believe I did.
200 times
that's
2 axles.
Ms. Bailey, if that's the agreement between the parties, I'll put $400. It's just something different in this court's file.
I'm so sorry, Your Honor. What did the court's file have?
The court's file has $3,780. That's a fine of $3,640, cost of $80, state cost of $20, and fund fee of $20. I'm sorry, state cost of $40 and fund fee of $20.
Oh, for an overweight axle?
Ms. Bailey, I'll stop talking. If your agreement with Mr. Somberg is $400, that's what I'll write in the file.
Yes, Your Honor, it is.
Okay, $400. Mr. Somberg, can your client pay that within 5 days?
Mr. Pingle, can you respond, please?
Yes, I can.
Yes, Your Honor.
Mr. Pingle, you can bring it to the court, you can mail it to the court, or you can pay it online, okay?
Yes, understood.
Anything else, Ms. Bailey? Oh, she's gone. Anything else, Mr. Somberg?
Oh, Your Honor, nothing further from the people.
Nothing from the defense, Your Honor. Thank you. Have a great day.
Thank you. Good luck to you, sir. Have a good afternoon.
You as well. Thank you.
Thank you. Attorney Hamilton and McCoy?
Yes.
You speak to, were you ready on McCoy?
Yes.
Okay. This is 220517 FY. This is State of Michigan versus McCoy. May I have your appearances, please?
Vanessa Hamilton on behalf of Mr. McCoy, Your Honor. Mr. McCoy appears via Zoom. Could you please state your name, Mr. McCoy?
Michael Leon McCoy.
Thank you.
Thank you. Today's the day and time set for the PCC in this matter. How are we proceeding this morning?
Your Honor, I have paper discovery. I've just requested digital discovery. I'd ask that we set this for a preliminary exam date, anticipating that we'll get that prior to that date.
I'm happy to set it with the digital discovery outstanding, but understand that if we get to the exam date, your excuse or request to adjourn cannot be based on the fact that you have not yet received it. My preference is that we wait until discovery is complete, but I'm happy to schedule the exam right now.
All right, thank you, Your Honor.
Mary Ann, that exam date will be
August 10th at 12:30.
Live exam date of August 10th at 12:30 p.m. here in courtroom number 1. Anything else on behalf of the people?
No, Your Honor, nothing further on behalf of the people.
Thank you. Anything else on behalf of the defendant?
No, Your Honor.
Thank you. We are all set in this matter. Mr. McCoy, August 10th at 12:30, back with me live in courtroom number 1. Thank you.
Thank you.
Ms. Richards.
She's in a breakout room, Judge.
I see she's with Tyler Miller. Thank you. Mr. Marks, have you spoken with her yet? No? Okay. We'll get you matched up with her. She's in the breakout room with somebody else, but I'll keep an eye on you. Mr. Geringer, good morning.
Good morning, Your Honor. Attorney Luke Geringer appearing on behalf of defendant Jordan Clark.
I wasn't quite calling your case yet. Have you spoken with your client this morning? Am I missing? Is Mr. Clark present?
Yes, ma'am.
Thank you. Did you need to speak to the prosecutor, or had you already spoken with her?
I spoke with her previously. I did have a chance to speak with Mr. Clark and discuss the offer that had previously been extended by the people.
Sir,
Yes.
I'm sorry. I asked if you're ready, so then I can call the case. If you need to
Yes.
speak to Ms.
No,
Bailey,
I am
would just
ready.
pass
I
the
am,
case.
Your Honor. I'm
Okay.
ready, Your Honor.
Thank you. This is 220443 FT. This is State of Michigan versus Jordan Clark. May I have your appearances, please?
Good morning, Your Honor. Britt Bailey on behalf of the people, P84009.
Good morning, Your Honor. Attorney Luke Geringer appearing on behalf of Jordan Clark, P85677.
Mr. Clark, state your name for me, please, sir.
Good morning, Your Honor. It's Jordan Clark.
Thank you. Now we are at the point where today is the day and time set for the PCC in this matter. Mr. Geringer, how are we proceeding?
Your Honor, after speaking with Ms. Bailey and Mr. Clark, he has decided to avail himself of the people's offer, which is to plead to 1 count of attempted fleeing and eluding, which is a 1-year misdemeanor, and a Killebrew to no upfront jail time.
Ms. Bailey?
Your Honor, that is the offer. And I'm fine with no upfront jail time. I don't recall discussing that, but I would, of course, just be asking for either probation or fines and costs as the court assesses.
Clark, raise your right hand for me, sir. Do you swear affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You may put your hand down. I'm sorry, and Mr. Geringer, as to the other three, the civil infractions,
Ms. Bailey, was the agreement was to just plead to the one count, correct?
We hadn't discussed the civil infractions. I
you all
don't
need to
recall.
speak.
Yes, I guess if we could just briefly pass on this
Okay.
matter. I
I'm
apologize,
not
Your
trying to
Honor.
cut you off. There's a few other things that are ready. If you want to give me a moment, let's get a couple of things cleared out and then we'll get you into a breakout room and discuss this in greater detail.
Okay, thank you, Your Honor.
This is 0S3725467 A and B. These are State of Michigan versus Gary Leeper.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Sir, state your name for me, please.
Gary J. Leeper, Your Honor.
Mr. Leeper, the way you're identified on the screen indicates that you're waiving your right to have the assistance of counsel this morning. Is that accurate, sir?
Yes, it is.
You intend to proceed on your own or represent yourself?
I do.
For purposes of arraignment, sir, what say you?
For purposes of arraignment,
Of arraignment, sir, today is the day and time set for your arraignment in this case.
yes.
Okay, Mr. Leeper, you look confused. What I would suggest is that you at least speak to the court-appointed attorney who might be able to give you some assistance and guidance on how to proceed this morning. You don't have to, the court can't make you speak to the attorney, but we're at the arraignment stage, which is your first appearance. And when I ask you to respond to the arraignment and you're not sure how to proceed, an attorney might be beneficial to you. He's available, he's sitting here this morning if you're ready.
Well, certainly.
Please go into a breakout room with Mr. Bowditch. He'll discuss the charges against you, the possible penalties that you face, sir.
Thank you, Your Honor.
Thank you. Ms. Richards, are we ready with Mr. Miller?
Yes, Your Honor, I'm ready on Miller and on Mr. Marks as well.
Thank you. This is 220507 FY. It's the State of Michigan versus Tyler Miller. May I have your appearances, please?
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
Good morning again, Your Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Miller, who is present via Zoom. Mr. Miller, could you state your name?
Tyler Miller.
Thank you. Today is the day and time set for the PCC in this matter. Ms. Richards, how are we proceeding?
Your Honor, at this time, I have not yet received discovery. So we are asking for another probable cause conference date. Mr. Miller is out on bond. I also spoke with Ms. Movisian about his bond, and I believe she's going to make a request to the court.
How long of an adjournment are we looking for before we get to the bond question?
Your Honor, I believe Ms. Movisian said that she would have the discovery to me by the end of the week. Mr. Miller being out on bond, it's less urgent than the last one, but we'd still like an early date, Your Honor.
Maybe 2 weeks?
That should be fine.
Marianne, is there space on August 3rd?
Yes, at 9:45.
August 3rd, 2022 at 9:45 a.m. And that's in number 2 with Chief Judge Brian Oakley. The bond request, ma'am?
Yes, Judge. I've spoken with the complainant in this case, Madison Mullins, multiple times. She is currently pregnant. She requested that the no contact order be amended to no assaultive contact so that the defendant can appear at her doctor's visits with her. And so that will be our request to amend the no contact order to no assaultive contact. I understand that the defendant is also on a tether, so I'm assuming that that tether would then be removed since it doesn't seem like it would be useful at that point.
We would have no
Mr.
objection.
I'm sorry, Ms. Richards.
I
What
was
did you
just
say?
saying we would have no objection to that, Your Honor.
Thank you. Mr. Miller, the court will modify your bond
Okay,
to
Your
change
Honor.
from no contact with the complainant to no assaultive contact. And will also remove the GPS tether in this matter. Please note that if this court receives a report that there has been assaultive contact with the complainant, the court could view that as a violation of your bond, revoke your bond, and you can spend the rest of these proceedings in custody. Are we on the same page, sir?
Yes, ma'am.
Thank you. Anything else, Madam Prosecutor?
No, that is it. Thank you.
Anything else, Ms. Richards?
No, Your Honor, thank you.
Thank you. Mr. Miller, we're all set, sir. Have a good day. Good luck to you.
Thank you. Have a good day.
Thank you. This is 220518FY, State of Michigan versus Stephen Marks. May I have your appearances, please?
Good morning, Your Honor. Sonam Movsisian on behalf of the people, P83923.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Marks, who is present via Zoom. Mr. Marks, can you state your name?
Stephen William Marks.
Thank you. Today is the day and time set for the PCC in this matter. Ms. Richards, how are we proceeding?
Your Honor, likewise, I haven't received discovery yet on behalf of Mr. Marks. I have spoken with Ms. Movisian, who indicates that she will have it to me by the end of the week. So we would ask for another PCC date. I think 2 weeks would be sufficient.
The next date is August 10th at 9:45.
August 10th at 9:45 a.m. That will be in number 3 with Judge Green. I've made a notation in the file that discovery has been requested. Anything else on behalf of the people?
No, that is all. Thank you, Your Honor.
Anything else, Ms. Richards?
No, Your Honor, thank you.
Thank you. Mr. Marks?
Yep.
Yes, back
Or
on
yes.
August 10th, 9:45 with Judge Green. Good luck to you, sir. Have a good afternoon.
Thank you. You have a wonderful rest of your day.
Thank you. Have we seen Ms. Phelps this morning for Mr. Garcia?
Thank you.
No, ma'am.
Good morning, Your Honor. I'm the intern for Ms. Phelps. I think she's currently in an exam right now.
Any direction on Mr. Garcia, which is scheduled at 9:30? No, it's okay. We still have other stuff going on. So Mr. Garcia, sit tight. As soon as we see your
Okay.
attorney, we'll get you matched up, get your case called, get you on your way. Mr.
Okay,
Bowdish,
thank
I
you.
see that you're back with Mr. Leeper.
Mr. Leeper is ready, Your Honor.
Recalling the cases that end in 467 A and B. Your appearances, please.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Leeper for these proceedings alone, Your Honor. Mr. Leeper has on his own already pre-tried this case. I believe the prosecutor wishes to dismiss the charges. Mr. Leeper, can you say your name for the judge?
Jerry J. Leeper, Your Honor.
Thank you, sir.
I'm sorry, the Madam Prosecutor is dismissing both counts, sir. You have to say it. I'm sorry.
I believe so.
You have to say it out loud for the record.
Yes.
Thank you.
Yes, Your Honor.
I hear you now. Thank you so much, Mr. Leeper, for your assistance. The court will note that both matters are dismissed. You have posted a bond in these matters. The bond will be returned to you less any fees that might be due to the court. Anything else, Mr. Leeper?
That'll do it. Thank you very much.
Thank you for your patience this morning, sir. Have a good day.
Your Honor, I would need a breakout room with Miss Bailey if she's available.
She will be after I recall Mr. Clark's case. Give me 1 second.
Thank you, ma'am.
This is a recall of 220443 FT along with the 3 civil infractions. This is State of Michigan versus Clark.
Jordan Bailey on behalf of the people, Your Honor.
Luke Garinger appearing on behalf of defendant Jordan Clark.
Thank you. When this case was called before, there was an indication that there would be a plea to attempt for fleeing of a police officer. And the question from this court was regarding the civil infractions that accompanied this matter. How are we proceeding, Mr. Geringer?
Yes, after discussing this further with Ms. Bailey and Mr. Clark, we've reached an agreement to plead to the no proof of insurance civil infraction and to dismiss the limited access speeding and disobeying a traffic stop signal.
And with the, I'm sorry. So we're pleading to the B file, no proof of insurance, and there's still the attempt flee on the lead file, the felony file.
That's correct.
That's your understanding. Okay, Mr. Clark, let's do this again, sir. Raise your right hand. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. You had the opportunity to discuss this case this morning with your attorney,
Yes, Your Honor.
and it's your understanding that you will be pleading guilty to count 1, attempted fleeing and looting of a police officer, 4th degree.
Yes, Your Honor.
And you'll be pleading responsible to having no proof of insurance.
Yes, Your Honor.
You understand that if the court accepts your pleas in these matters, you will not have a trial of any kind.
Yes, Your Honor.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes, Your Honor.
And you're entering these pleas freely and voluntarily.
Yes, ma'am.
You haven't been promised anything, threatened in any way.
No, Your Honor.
Sir, you're pleading guilty and responsible because you are in fact guilty and responsible.
Yes, Your Honor.
Sir, is it true that on June 13, 2022, in the city of Romulus County, Wayne State of Michigan, you attempted to flee from a police officer who had given you a visual or audible signal by hand, voice, or emergency light?
Yes, Your Honor.
And that police officer was in uniform and the officer's vehicle was identified as an official police vehicle?
Yes, Your Honor.
Sir, is it also true that on June 13, 2022, you operated a vehicle with no proof of insurance?
Yes, Your Honor.
Satisfied, Mr. Geringer?
Defendant satisfied.
Satisfied, Ms. Bailey?
Yes, Your Honor, the people are satisfied.
Thank you. Mr. Clark, the court accepts your plea of guilty to attempted fleeing police officer, 4th degree, and no proof of insurance. The other 2 civil infractions, the 16 to 25 over the postal limit, is hereby dismissed, and the failing to obey a stop sign is also dismissed. Ms. Bailey, there have been some conversation that the parties had agreed to no jail time. Is this a matter that needs to be referred to probation for sentence recommendation?
Yes.
Mr. Clark, the court will refer the matter down to the probation department. They will do an interview of you and they will make a recommendation for your sentencing. They are the ones that schedule the sentencing with the court. So you will receive emails and phone calls from them at the phone number previously provided to the court. Please respond to their efforts to be in communication with you so that they can timely get this recommendation completed and back up to me for review and sentencing, okay?
Yes, Your Honor.
Anything else on behalf of the people?
No, Your Honor.
Anything else on behalf of Mr. Clark?
Nothing further, Your Honor.
Thank you. Mr. Clark, I'll see you in a few weeks, sir. Good luck to you. Have a good afternoon.
Thank you, Your Honor.
Thank you.
Have a good
Thank
afternoon.
you. Good morning, Ms. Phelps.
Good morning, Judge.
How are you, ma'am?
I'm well. How are you?
I am wonderful. We have a couple with you this morning, starting with Mr. Garcia. You're labeled as Murphy and Smith.
I'm sorry. Let me get my headphones connected. I'm having a hard time hearing you. Give me 1 second. Okay, can you hear me, Judge?
I am able to hear you, ma'am. Thank you. I said you are labeled as Murphy and Smith, but I know that there is a Mr. Garcia here waiting to see you.
That's an old label. I'm sorry, Judge. So I only have Mr. Garcia here this morning, and we've already had a chance to communicate. And I do have an intern here who would like to go on the record with the PCC if that's okay with you.
Let me call the case, and this is, the prosecutor is listed as a Keith Wright.
He signed the warrant, Your Honor. It will be
Ms.
me.
Bailey.
Yes, Your Honor.
Okay. This is 190195FY. This is State of Michigan versus Tyler Garcia. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355. I'm moving for Carrie Pemberton to practice pursuant to MCR 8.120 for today's hearing. She's a second-year law student in good standing at the University of Michigan Law School, appearing under my supervision.
That request is granted. Ms. Pemberton, you go to an absolutely fine institution. I'm not biased at all.
Thank you.
Mr.
Good morning.
Garcia, state your name for the record, please. I'm sorry. Mr. Garcia?
Oh, Tyler Lee Garcia.
Thank you. Ms. Pemberton, I cut you off. Today is the day and time set for the arraignment in this matter, ma'am. What say you for purposes of arraignment?
Your Honor, we've not received discovery yet, so we would be requesting physical and digital discovery and would like to schedule it for an in-person preliminary examination.
And Your Honor, as to the arraignment, we would stand mute to the charges and waive the formal reading of the charges.
Thank you. Ms. Pemberton, I'll make the indication in the file that discovery has been requested. This court typically likes discovery to at least be in your hands before we schedule a live exam, but I'm happy to do that. But as I indicated on the record previously, this court does not adjourn exams because discovery is not complete when you've had the opportunity to complete it beforehand.
Your Honor, in that case, we would request an additional PCC instead of scheduling straight to exam.
We will get that exam, I'm sorry, that adjourned PCC date, but let's address the question of bond. There is a recommendation from law enforcement, from back in January of 2019, asking that Mr. Garcia's bond be set at $75,000, 10%. I don't see a more updated bond request. Ms. Pemberton, your argument as to bond or pretrial release in this matter.
Your Honor, as to bonds, we would ask for a personal bond in this case. Mr. Garcia has voluntarily appeared here today. He doesn't have any history of failing to appear for court, and he is working. So we would ask, and he's not a danger to the community, nor is he a flight risk. So we would ask for a personal bond in this case.
Mr. Garcia's bond will be set at $10,000 personal. Mr. Garcia, you do not need to post any money, but what you must do is appear at all future court dates and continue to participate in these proceedings until they are resolved in their entirety. As Ms. Phelps has indicated, Mr. Garcia appeared timely and appropriately this morning. We don't see a reason for a cash bond in this case. That adjourned PCC date will be August 10th at 10 o'clock. I'm sorry, there's something in the background. I can't hear you, Marianne. August
10th at 10 o'clock.
August 10th, 2022 at 10 a.m. And that will be by Zoom in number 3 with Judge Green. Anything else on behalf of the people?
Nothing further. Thank you, Judge.
Anything else, Ms. Pemberton?
Nothing else. Thank you.
Thank you, ma'am. Ms. Phelps, thank you. Mr. Garcia. August 10th with Judge Green, sir. Have a good day.
Thanks, you too.
Thank you.
Thank you.
Thank you.
Mary Ann,
Yes,
I'm going to be speaking with Shirley, D. Shirley, on behalf of Mr. Bitar. David Shirley.
Thank you. Oh, Kathy.
Jeff, do you need a breakout room with him or are you set?
I need a breakout room with Miss Bailey first, or Mr. Gambino, and then I'll talk with Mr. Shirley.
I think you can just go into Bryn's.
Okay, thank you.
Yep.
Mm.
You invited me to join you, Judge?
I did, ma'am. I have two files that need your expertise.
All right.
There's two that tethered to be released, and there's a bond modification. They're just on the rail when you get a chance, or send an officer in, please.
Yep, I will. Thank you so much.
Thank you so much. Ryan Johnson?
I'm
Yes,
trying to
ma'am.
grab him to go in to see me so I can get his information.
Thank you, because I don't see that.
Yeah.
Okay.
Mr. Johnson, if you have a spot that says join, please join it.
Okay.
Thank you.
Oh, because the time is wrong. Yes, maybe. 10:30, Mr. Johnson. Marianne, I'm coming right back, so if they pop out of the breakout.
Okay.
Which is fine usually. Mary Ann, the rumor in the street, I don't know what the street is, but there's a rumor in the street that Mr. Day is jumping on, and we will be adjourning his recently retained file from this afternoon's docket. Ezel, I think it is.
He's the 12:30, Lonnie Weinstein.
Weinstein, thank you. So if our 12:30 and our 1 o'clock are adjourned, there will actually be lunch today for staff. So it's beautiful. Okay. And there's Mr. Nunley. Are we ready on something? Am I missing a match set? Good morning, Mr. Nunley.
Good morning, Judge. How are you?
I'm super. How are you?
Doing excellent, thanks.
Do you need to speak to Ms. Bailey regarding McGinty?
No, I don't think so.
Okay. I was looking to see if any of our earlier scheduled cases were ready before I call this 10 o'clock case. Looks like the answer is no. This is 22. I don't see your client. Are you expecting her, Mr. Nunley?
So something happened with her phone number the last time that we were here on this matter. And I'd been in constant contact with her, but before the last time we were here, her phone was like not connected. I got one of those strange messages from the provider. We adjourned to give Ms. Bailey an opportunity to respond to the motion.
I'm sorry, she's here.
Oh,
They
she
just
is.
renamed her. She was here by phone. She's
Oh.
with Heather right now.
Oh, okay.
So there, Heather's just verifying her contact information. Then when she comes back in the main session, I'll call the case.
Okay.
I did not see a response from you, Ms. Bailey. Did you file something or submit something to the court?
No, Your Honor. I did not have the time to write something formal, but I can respond orally today.
Okay, if you give me a moment when she pops out. She's out. This is 220342 SD. This is State of Michigan versus Becky McGinnity. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Royce Dunley appearing on behalf of the defendant.
Ms. McGinnity, are you with us?
Yes, I'm here.
State your name for me, ma'am.
Becky McGinnity.
Thank you. Today is the day and time set for the adjourned arraignment and pretrial and defense motion for a speedy trial. Motion to dismiss due to speedy trial violation. Mr. Nunley, it's your motion.
Yes, Your Honor. So I know that the court has received the motion in the brief, and I'm sure that this court has reviewed it. So I won't belabor the point too much, but I will hit several highlights. So she was charged April 24th, 2020. Now, the complaint didn't get authorized in this case until May 4th, 2022. So we're talking over 2 years of a delay. For no reason that I could ascertain by looking through the discovery materials. The discovery materials, the police report actually like mentioned that they sent the complaint over to be authorized at some point on May 12, 2020, when the blood analysis came back. And then later in the report, it says that a detective was reviewing an old case file on July 8th, 2021. And notice that the complaint has not yet then been authorized and sent it over again. So I can't find any reason whatsoever why the delay of 2 years happened. However, according to the Constitution, statutory law, the case law, because of this delay, Ms. McGinnity's right to a speedy trial has been violated. There's the 4-part speedy trial test that's been around for quite a while, I think since the 70s. The case is Barker v. Wingo, and it's a 4-step analysis. The first one, I think, being really important is the length of the delay, because following a delay of more than 18 months, the burden shifts to the prosecution to show that the defendant has not been prejudiced by the delay. So in other words, the prosecution has to prove to this court or give a good enough reason to satisfy this court that Ms. McGinnity's rights have not been, well, that she hasn't been prejudiced by the delay in this case. Now, so the second one is the length of the delay, or the reason for the delay, rather, that the court has to take into consideration. Unexplained delays are weighed against the prosecution. So if there's no reason for the delay, because sometimes there's delays in extremely complicated cases in which the court is supposed to give a little bit more latitude. But the flip side of the coin is when it's a pretty straightforward case, then the court should kind of give it a little bit more scrutiny, if you will. I mean, this just seems like a standard OWI. Thousands of these are done a year. It's not a very complicated case. And there's no reason, because for the delay, the lab results from the blood analysis came back within, I don't know, a few weeks, 3 or 4 weeks of the arrest. So at that time, they had everything that they would have needed to move forward with these charges. The third thing the court needs to take into consideration is the assertion of the right. She can't assert her right to a speedy trial if she doesn't know that she has a charge pending against her, or, well, I mean, I guess a complaint hadn't been authorized. So that one is pretty much irrelevant to the analysis in this case. And then the last factor is the prejudice to the defense, right? So this arose out of, it was like a 2-part, there was like a domestic violence call or something where somebody complained and alleged that Ms. McGinnity had gone to their house and done something. And then there was a traffic stop. Like most of these like OWI cases, you know, they start with the traffic stop. And your biggest piece of evidence as a defense attorney that you want to look at is the videos from the traffic stop to see if there's a good stop, because sometimes those are the only ways in which you can really challenge these charges. So there is no video from the traffic stop that has been supplied throughout these discovery materials. And they also alleged, and this part is interesting, they alleged that there was a recorded confession from Ms. McGinnity, and that was not supplied to me in the beginning. Like, I did not receive that until last week. So after filing this motion and having it adjourned for, you know, to give the prosecutor some time to respond, coming back, now all of a sudden they found it. I mean, they had a duty to provide me with all of the discovery that they had in this case. And lo and behold, they send me a police report and say, well, that's it. And then I file a motion to dismiss, and then magically some other evidence appears. A little bit suspect. Okay, so the evidence appears that will help the prosecution's case, this alleged confession. However, any sort of video of the traffic stop or whatever, which may give, you know, a defendant an opportunity to challenge the stop, that's still not around. So the prejudice to Ms. McGinnity by not having these videos of the traffic stop are clear, right? But another sort of prejudice that the Supreme Court of the United States, like, you know, made a point to belabor is sometimes the biggest prejudice to the defense is the lack of memories of people, you know, memories fading over the course of 2 years. And they also recognize that sometimes that's the hardest prejudice to prove, right? Because how do you prove that somebody's memories have faded over time? Now, I know that officers make so many of these arrests every year. I don't know how many, but monthly, yearly, we're probably talking hundreds and hundreds of traffic stops and arrests. So the only real witness testimony that we could expect to have in this case would be the testimony of the arresting officers. Now, it is extremely unlikely that they remember not only the stop from 2 years ago, but even if they remember the stop, like sufficient details for any sort of meaningful cross-examination. So if this case weren't to be dismissed and it were to go to trial and these officers get on the stand to testify as to what happened, it's safe to say that they're going to rely heavily on their police reports because they're just not, through no fault of their own, they're just not going to remember a stop in sufficient detail from 2 years ago. So I think the prejudice in this case is clear. And I guess it's important to reiterate that it is now, because more than 18 months have passed, it's now on the prosecutor, their burden to prove that Ms. McGinnity has not been prejudiced by the delay. So for these reasons and the other reasons that I've argued in more detail in the brief, we would ask the court to grant the motion and dismiss this case of prejudice.
Bailey.
So, Your Honor, a couple of things. To start with, the statute of limitations for bringing charges is 6 years per Michigan law. The Sixth Amendment of the Constitution does not provide for a right to be arrested. And the right to a speedy trial is not applicable until they actually become accused. And the courts have held that a formal filing of an indictment, or in this case, a complaint and warrant, is when that right starts. So not arguably, Your Honor, according to law, Ms. McGinnity's right to a speedy trial didn't attach until May 4th of this year. So therefore, Your Honor, we have had less than 3 months delay since she was initially charged to today's date. And Your Honor, what we're concerned more is actual prejudice, not the delay itself, which according to People v. Torres, 90 Mishap 120. Additionally, Your Honor, in U.S. v. Crouch, 84 F.3D 1497 from the Fifth Circuit, vague assertions of lost witnesses, faded memories, or misplaced documents are inefficient to establish that actual prejudice has been created. So I'm so sorry, I got distracted. A formal indictment or information or the actual restraints imposed by arrest and holding to answer for a criminal charge are what creates that right to a speedy trial, which is from U.S. v. Marion 404 U.S. 303 or 307, Your Honor, I'm sorry, at 320 and 325, 1971. So the defendant is presumed to have suffered no prejudice in the distance between the alleged offense dates and their arraignments and subsequent prosecution, and they must themselves demonstrate that a pre-arrest delay was prejudicial. The police reports were provided, the interrogation has been provided, and there has been no allegations that the government, on behalf of the police or the prosecution, have intentionally withheld things to gain a tactical advantage over this prosecution, Your Honor, which is what is required, that there must be a showing that the both actual and substantial prejudice has been given, as well as an intentional delay on behalf of the government. Mr. Nunley hasn't provided any evidence that the people intentionally waited a year on the warrant to authorize it, Your Honor. This incident happened 1 month into a global pandemic that completely shut down the world. The delays in charging cases has been a common occurrence, and the sheer backlog and change in systems that were required is not intentional on behalf of the people. And that sort of delay the courts have ruled. Is not something, is something that is less substantial and less burdensome than otherwise. An overcrowded docket, or in this case, an overcrowded warrant system, is a potential valid reason for appropriate delay, which is listed out in Barker v. Wingo. Additionally, Your Honor, people are under no duty to file charges as soon as we have probable cause. That is from US v. Lavasco, 431 US 783. So, Your Honor, the people would argue that there has been no violation to the right of speedy trial. It has been less than 2 months since this defendant was in fact formally charged with a complaint and warrant for her arrest. And therefore, that is when the right to a speedy trial attaches, and the Barker factors are inapplicable at this point because we are not over 18 months. We are simply at 2 months.
May I respond, Your Honor?
I don't know that Ms. Bailey was done.
Oh, I'm sorry.
Pause, but I didn't know that that necessarily meant you were done, ma'am.
I'm sorry. I don't mean to jump the gun, Ms. Bailey.
Just that People v. Adams, Your Honor, indicates that as long as the delay was not deliberate to disadvantage the defense, then there has been no showing of actual substantial prejudice, which is what is needed per People v. Adams, 232 Mishap 128. And that is all that I have, Your Honor.
Thank you, Mr. Nunley.
Okay, so a few things. With all due respect, Ms. Bailey, I think that her argument regarding when the speedy trial clock starts ticking is just wrong. So the case that she cites herself, United States v. Marion. So she cites that case.
I'm sorry, Mr. Nunley.
No
You
problem.
can't go back to, Ms. Richards was supposed to get a new address from him. So call Ms. Richards. Thank you, yes. I'm sorry.
That's okay. So the right to a speedy trial goes from arrest. So, and that is People v. Williams, a lot of cases, but the one that I have cited in my brief, quote, "The time for judging whether the right to a speedy trial has been violated runs from the date of defendant's arrest," unquote. There's about 150, maybe 1,000 other cases that quote the same language that stand for the same purpose. Now, Ms. Bailey cites to United States v. Marion. That case, there wasn't a formal arrest. There was like an investigation, and then they decided to issue an arrest warrant. And then the person, by that time, he had been serving time in, I think, a jail in like Kentucky or Tennessee. So the court found that, well, he was never arrested. They did an investigation, they issued a warrant, and then they weren't able to pick him up on a warrant. However, when a person is arrested, like, for example, with an OWI, you're pulled over, you're arrested, you're put in jail for the night, and then they issue the complaint, and the prosecution has to authorize the complaint. No, it's time for the clock starts running at the date of a defendant's arrest. That cannot be any more clear in the case law as to when you should start that clock. Now, they defined arrest, People v. Marion itself defines arrest is a public act that may seriously interfere with the defendant's liberty, whether he is free on bail or not, and that may disrupt his employment, drain financial resources, curtail associations, so on and so forth. So the case that Ms. Bailey relies on defines arrest, and this most certainly was an arrest. Another, I think, flaw in Ms. Bailey's argument is she is really trying to switch the burden onto Ms. McGinnity to say that, well, she hasn't shown any prejudice. She doesn't have to. More than 18 months have passed, and the defense has, the prosecution has the burden to show that she has not been prejudiced. I haven't heard anything about how she has not been prejudiced by the disappearance of these videos that would have, shown the arrest in the field sobriety test or lack thereof, because the report states that they decided not to do field sobriety tests. Okay, well, that could be important to know why. And further, another thing I want to point out is Ms. Bailey seems to think that if there wasn't malice or like a bad intention for the delay, then it shouldn't be counted against the prosecution. But that's not true either. Quote unquote, unexplained delays are to be weighed against the prosecutor. People v. Granberry from the Michigan Court of Appeals. Intentional delays, the Supreme Court has held, have to be weighed strongly against the prosecution if they're intentionally doing something to gain some sort of tactical advantage. However, they go on to also say, but unexplained delays also are weighed against the prosecution, but not with the same weight as intentional delays. Now, so Doggett v. United States from the Supreme Court of Michigan, they provided that condoning prolonged and unjustifiable delays in prosecution would both penalize many defendants for the state's fault and simply encourage the government to gamble with the interests of criminal suspects assigned a low prosecutorial priority. Now, the excuse that I hear about COVID is slowed things down and they have a large docket. I understand that. I sympathize with that. However, that does not negate my client's constitutional right to a speedy trial. Complaints were still getting authorized all the time during COVID. I understand Wayne County's prosecutor's office is extremely busy and I empathize. However, 2 years when the police department sent it over twice, there's just no excuse for that. And my client has been prejudiced by this delay. I haven't heard any argument as to how she hasn't been prejudiced by this delay. And as the burden switched to the prosecutor after 18 months, and as the speedy clock started ticking on the date of arrest, which cannot be any clearer in the case law, imagine it if Ms. Bailey was right. You can arrest somebody, take them to jail, release them, and then wait 24 years later and then say, oh, let's issue this warrant. Imagine. Like it just defies logic and it defies the clearly defined case law. So for those reasons, we would ask the court to grant the motion.
Your Honor, I just have one more point, if the court would indulge me.
Yes, ma'am.
So Doggett v. U.S. 505 U.S. 647 from 1992, quote, the clock begins on speedy trial calculations with the institution of formal proceedings, either through indictment or the issuance of an arrest warrant, unquote. Your Honor, the case that Mr. Nunley cited, U.S. v. Marion, which I also cited myself, is what, 21 years prior with his definition of when speedy trial begins, which is at arrest. So, Your Honor, the presence of Doggett v. U.S. does in fact change the definition of when speedy trial calculations begin. It is not with arrest. It is with formal proceedings.
Anything else, Mr. Nunley?
No, I'll rest on my prior argument.
Thank you. The court has had the opportunity to review the motion in its entirety, review the cited cases, and listen to the argument of the attorneys this morning. This court will grant the defense motion to dismiss this case with prejudice. I understand that we went into this COVID worldwide shutdown back in 2020, but this court has seen cases charged after that, with blood results after that, and have already conducted trials and exams on them. So that's not a valid excuse for this delay. This court is bothered by the fact that videos disappear and reappear in part. This is the second time this week this has happened. That's a violation of discovery, which Mr. Nunley raised a little, but I have great concern when there are videos, multiple videos, and there's only one produced. That resolves this case in its entirety. Anything else, Ms. Bailey?
No, Your Honor.
Anything else, Mr. Nunley?
Nothing further. Thank you, Your Honor.
Ms. McGinnity, we're all set, ma'am. Have a wonderful day.
Thank you, Your Honor. You too.
Thank you. Ms. Bailey, off your afternoon docket, there's 220141 FT. This is the People versus Lonnie Weisenstein. This matter is scheduled for exam this afternoon at 12:30 p.m. This court received an appearance in this matter from Attorney John Day yesterday. May I have your appearances, please?
Your Honor, I believe I handed this to Mr. Kazak to handle.
I'm sorry, Your Honor. Yep, Michael Kazak, POP 214.
Say your appearance, sir.
I'm sorry, Your Honor, did you call my case?
I did, sir.
I'm sorry, my thing paused. John Day appearing on behalf of Mr. Weinstein.
Thank you. As I was indicating, Mr. Day, this case is scheduled for exam this afternoon at 12:30. This court received your appearance yesterday and presumed that a request to adjourn would be forthcoming. This exam was scheduled back on April the 27th, 2022, which time the defendant in this case was represented by Tyrone Bicker. Mr. Day, am I guessing?
Your Honor, you could not be more correct. I was contacted. I'm sorry?
I'm sorry. Go ahead, Mr. Day.
Just so you understand, Your Honor, the client came in, retained me on Monday. I immediately sent over the appearance. And then I called the court to find out exactly what was going on because the appearance form he gave me was for a different date. And when I received Mary Ann's phone call yesterday, found out it was for a preliminary exam. I go, wait a minute. You told me this is a misdemeanor OWI, and now it's a felony charge. So I need to do a little bit of research.
And Your Honor, people have no objection.
I'm sorry. Go ahead, sir.
Oh, I apologize, Your Honor. Your Honor, the people have no objection to the adjournment request, given the circumstances.
Thank you, sir.
The new date will be
August 17th at 2 o'clock.
Thank you, Your Honor.
August 17th, 2022 at 2 p.m. Live here with me in courtroom number 1. Mr. Day, what I was asking was about discovery. I don't see discovery notes earlier in the file. Have you already requested it from the prosecutor's office, or do you need it?
No, I will be doing that later today.
And Your Honor, I'll make sure Mr. Day gets the materials. I'm actually gonna pull it up right now and send them to him, so we'll have those.
I wouldn't mind talking to you, Mr. Kazak. I got some questions about the file.
Okay.
Well, you don't need me to talk, but is there anything else on behalf of the people?
No, thank you very much, Your Honor.
Anything
Your
else,
Honor,
Mr. Day?
We're fine, Your Honor. Will the court be sending out new notice?
Do you want Mary Ann to move you into a breakout room?
Yes.
That'd be great, Your Honor. Thank you.
Yeah, thank you.
Thank you. Are we ready on Gambino?
Ready, Your Honor.
This is 220502 SM. This is, take your cap off, sir, State of Michigan versus Zachary Gambino. May I have your appearances, please?
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Gambino. Mr. Gambino, would you state your name for the record, please?
Yes, Zachary Tyler Gambino.
Your Honor, today is a date and time set for a pretrial in this matter. I've had a chance to talk to the prosecutor. Mr. Gambino wishes to plead no contest, possible civil litigation to the charge of disorderly person, with the understanding the matter would be taken under 771 for a period of 6 months.
Mr. Gambino, raise your right hand for me, please, sir. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you. Put your hand down. Thank you. Sir, you understand that the court accepts your plea of guilty to being a disorderly person. You will not have a trial of any kind in this matter?
I'm sorry, the audio went out a little bit. Could you repeat that, Your Honor?
The plea, Your Honor, no contest.
Oh, thank you, Mr. Bowditch.
Yes, ma'am.
Mr. Gambino, you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes, Your Honor.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes, Your Honor.
And sir, you're entering this plea freely and voluntarily?
Yes, Your Honor.
You haven't been threatened in any way, promised anything to enter into this plea, this no contest plea?
Yes, Your Honor.
And sir, because you're pleading no contest based on the possibility of civil litigation, is it your desire to have the court rely on the police report in this matter as the factual basis for the claim?
Yes, Your Honor.
Thank you. Mr. Ballard, just so we're all on the same page, the file indicates that on July 5th, 2022, Huron Township Police found Mr. Zachary Gambino to have assaulted and battered one Jameson Gambino, contrary to MCL 750.81 sub 1. Is that your understanding as well, sir?
Yes, Your Honor.
Because this is a no contest plea, the court will take that as the factual basis for the claim. Since this matter is delayed for a period of 6 months, as to the fines and the cost assessed in this matter, Mr. Baldridge, do you have any comment?
No, Your Honor. Other than the fact
Mr.
that
Gambino?
Mr. Gambino is a veteran, Your Honor, and I believe he's on somewhat of a limited income at this point in time.
Mr. Gambino, the court will set your cost at $300, sir. Are you able to
Thank
pay
you,
that
Your
within
Honor.
the next 5 days?
Yes, Your Honor.
Mr. Gambino, are you able to pay that within the next 5 days?
Yes, I'll be able to do that, Your Honor. I have a
Okay.
fiduciary that handles all of my disability earnings. I'll be able to do that.
Thank you. Additionally, Mr. Gambino, what will happen is that the court will review the file administratively in 6 months, and so long as you have incurred no new criminal offenses, the matter will be reviewed for dismissal. Anything else, Mr. Bowditch?
Nothing, Your Honor.
Thank you. Mr. Gambino, good luck to you, sir. Have a good day.
Thank you, Your Honor. You too.
Thank you, Mr. Gambino.
Thank you, Mr. Bowditch.
These are 201685 FY and 220289 FY. These are State of Michigan versus Timothy King. May I have your appearances, please?
Good morning again, Your Honor. Sonam Mofsissine on behalf of the people. Excuse me, P83923.
Good morning, Your Honor. Neighborhood Defender Service by way of Emily New, P85234 on behalf of Timothy King.
And where's Mr. King?
And if Your Honor, if he is not in the waiting room, I have no information about his whereabouts.
I'm sorry, the court received a chat that we were ready to go on Timothy King.
I don't believe Timothy King will be appearing. If he hasn't already signed in, I don't believe he'll be appearing.
Both of these matters were scheduled for PCC this morning. How are we proceeding?
Judge, at this time, the people would request a bench warrant. I believe last time we were here, we had a similar problem, but we adjourned just given the fact that it was rescheduled and maybe Mr. King may had not known about that court date. And correct me if I'm wrong, Ms. New, I believe, has attempted to reach him and has been unsuccessful in doing so. And therefore, the people would request a bench warrant.
And that is correct, Your Honor.
Thank you. The matter was scheduled for 10:30 this morning. It's 10:37 by this court's clock. Mr. King has a history of failing to appear in both of these cases over the course of their existence. This court will issue bench warrant 5,010%. Anything else on behalf of the people?
No, that is all. Thank you so much.
Anything else on behalf of Mr. King?
No, Your Honor. Thank you. And thank you, Miss.
Thank you.
Thank you.
Thank you. Judge, I'll see you later this afternoon.
Thank you, ma'am. Have a good afternoon.
Bye-bye.
Mary Ann, I need a breakout room with Miss Bailey.
Okay.
Thank you, ma'am.
Mr. Bryant and Attorney James.
Good morning, Your Honor.
Good morning. I saw you check in earlier. My apologies. This is 220314 FY. This is State of Michigan versus Sincere Bryant.
Good morning, Your Honor, but he's at POP 82114.
And good morning, Your Honor, Nicole James, appearing on behalf of Mr. Bryant. My P number is 58961.
Thank you. Mr. Bryant, state your name for me, sir.
Sincere Bryant.
Thank you so much. Today is the day and time set for the PCC in this matter. Miss James, how are we proceeding?
Judge, I am still in need of discovery in this matter.
All discovery, or have you received some already?
Haven't received anything.
Your Honor, I'll make sure Ms. James gets that this morning here. It looks like it's been uploaded, so I hopefully can get all that over to her here.
So Judge, I don't know if the court wants to do another probable cause conference date or set an exam date. I don't know anything about the case, so.
It's your preference. If we schedule a live exam, the lack of discovery or incomplete discovery will not be a basis to adjourn the exam. But if you want to adjourn the PCC to see what the prosecutor provides and make sure it's complete and then set it for exam, or do you want to set it for exam? However you wish to
Okay, that's
proceed.
preferable. If we could have another probable cause conference date.
That date will be
August 10th at 10 o'clock.
August 10th at 10 a.m. back on Zoom in number 3 with Judge Green.
Judge, is it possible to have it the following week? I start a trial on August 8th.
August the 17th at
9 o'clock.
August the 17th at 9 a.m. They'll still be in number 3 with Judge Green.
Okay, thank you.
Anything else on behalf of the people?
No, thank you, Your Honor.
No, Your Honor, thank you.
Anything else, Ms. James?
No, Your Honor, thank you.
Thank you. Mr. Bryant, August 17th with Judge Green. Have a good afternoon, sir.
Okay, thank you.
Thank you.
Have a good one, everyone.
You too. Mr. Bowditch, are you covering for Mr. Bitar today, or are we expecting him? Oh, maybe not. Oh, yeah. This is 22BL003548 and B. These are State of Michigan versus Ahmed Al-Najjar. These matters were scheduled for show cause arraignment pretrial at 8 a.m. It's now 10:42 a.m. by this court's clock. I have not seen the defendant this morning based on his failure to appear as directed by this court. Bench warrant shall issue in both matters, 5,000. I'm sorry, the bench warrant will be in the A file. This is 22L55.
Your Honor, we're ready on Mr. Shirley if the court is. I'm sorry.
Oh, thank you. These are 2S4068589 A and B. These are State of Michigan versus David Shirley. May I have your appearances, please?
Your Honor, for the record.
Bryn Bailey on behalf of the people, Your Honor.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and in place of the attorney of record, Mr. Dan Bitar. Mr. Shirley, do I have your permission to proceed today?
Yes.
Your Honor, I've had a chance to. Mr. Shirley, would you give your name for the judge, please?
David H. Shirley.
Thank you, sir. Your Honor, we have had a chance to pre-try this case. At this time, Mr. Shirley would be pleading guilty to one axle of a vehicle being overweight, the designated fine of $200.
That is correct, Your Honor, and I would dismiss the unregistered count.
Charlie, raise your right hand for me, please, sir. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do. Yes.
Thank you. You put your hand down. Thank you. Sir, you were able to hear Mr. Bowdish just now indicating that you'll be pleading guilty to one axle overweight with a fine of $200.
Correct.
You understand that if the court accepts that plea this morning, you will not have a trial of any kind.
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Okay.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything?
No, I have not.
Sir, is it true that on June 16, 2022, Michigan State Police found you to be in Van Buren Township, County of Wayne, State of Michigan,
Yes.
with one axle overweight?
Yes.
Satisfied, Ms. Bailey?
People are satisfied, Your Honor.
Satisfied, Mr. Bowditch?
Satisfied, Your Honor.
Mr. Shirley, the court accepts your plea. One axle overweight will assess the $200 agreed by and between the parties. Sir, are you able to pay that within 5 days?
Yes.
Thank you. You can bring it to the court, you can mail it to the court, or you can pay it online. Anything else, Ms. Bailey, in this matter?
No, Your Honor, nothing further.
Anything else, Mr. Bowditch?
Nothing further, Your Honor. Thank you.
Thank you. Mr. Shirley, have a good day. You're all
Thank
set.
you. You as well.
Thank you. Mr. Bowditch, are we ready on Brian Johnson?
No, Your Honor, I have to speak with him.
Okay, thank you. This is 22L552685 AOT. This is State of Michigan, I'm sorry, Wayne County Sheriff's versus Chad Arrington. This matter was scheduled for a show cause arraignment pretrial at 8 a.m. It is now 10:46 a.m. by this court's clock. Defendant has failed to appear as directed by the court. Bench warrant shall issue in this matter. 1,010%. Did Mr. Johnson not join you, Mr. Bowditch?
No, Your Honor, he hasn't joined yet. Maybe I can move him in there.
I tried to join, but it kicked me out the break room.
I think I'm going to move you in.
Okay.
I can find the waiting room. I can't find the meeting room, or I can't find the. Mary Ann, you might have to help me on this one.
These are 22RP02420 A, B, and C. These are State of Michigan versus Sean Breyer. These matters were scheduled at 8:45 a.m. It's now 10:47 a.m. by the court's clock. Defendant having failed to appear as directed by this court. The civil infractions, which is the C file, will be deemed in default. The A and B files being misdemeanors, we set for show cause. These are 2S40689995 A, B, and C. These are State of Michigan versus Jimmy Construction. These matters were scheduled for pre-hearing and arraignment pretrial at 9:15 a.m. It's now 10:49 a.m. by the court's clock. Defendant having failed to appear. The B and C files, which are civil infractions, will be deemed in default. Show cause shall issue in the A file misdemeanor. This is 2S407946 ST. This is State of Michigan versus Naima Bray. This matter was scheduled for arraignment pretrial at 9:30 a.m. It is now 10:50 a.m. by the court's clock. Defendant having failed to appear. This matter will be set for show cause. These are 2S40794456 A and B. These are State of Michigan versus Tommy Bray. These matters were scheduled for arraignment, pretrial, and pre-hearing at 9:30 a.m. It's now 10:51 a.m. by this court's clock. Defendant having failed to appear as directed by the court. The B file civil infraction will be deemed in default and show cause shall issue in the A file. Are we ready on Johnson, or do you need to speak to Ms. Bailey?
Your Honor, I need to speak whichever prosecutor's handling the misdemeanors. I'm not sure if that's Mr. Zakari or Ms. Bailey, or Mr. Zayak.
Your Honor, if you can, if the court would put me in a breakout room with Mr. Bodish, that'd be great.
Thank you. I thought we saw Mr. Wiley at one point. Oh, Mr. Chambers never came back.
What about Miss Michon on Miss Cunningham?
Miss Michon and Miss Cunningham, we are adjourned to August 3rd at 9:30 a.m.
For another PCC, Your Honor?
Seriously, I'm sorry?
For another PCC, Your Honor?
Yes, ma'am.
Okay.
And that's all I have left. I have Wiley and Arnie Chambers was here, said that Mr. Wiley was down at with Judge Hathaway in circuit court. He was gonna check on Division 2 and come back, and I haven't seen him, and I haven't heard anything.
I haven't either, Your Honor. And then Mr. Tuttles and Mr. Bickert on Wells, Cadell, and Black. Their adjournment requests. And then prelims are all we have left.
That was the first thing I did this morning. We adjourned Wells Cadell to 8:17 at 1:30.
8:17 at 1:30.
Yes, ma'am. Mr. Day, which is, that's the 12 o'clock case. The 12:30 case was adjourned to 8:17 at 2 p.m. The Weisenstein.
Yes.
But your counterpart talked to Mr. Day, the new attorney, about that. And then the 1 o'clock case, Black case with Tuttles, is adjourned to 8:17 at 1 p.m. So after we do these, we have an exam at 11:30, and then we have a break until 1:30. And as soon as Mr. Johnson pops back out, we'll get that case called, and then we have 2 formal hearings at 11 and 11:15. And that's all, that would be all that I have outstanding for the morning, just the 2 formal hearings and Mr. Johnson's case that we'll call momentarily.
You know, Your Honor, I'm ready on Johnson, but I can't get him out of the breakout room because the list that I have that says join is always covered by something.
He's fine. Give it a second. I'm pulling
All
him
right.
out.
It's just an adjournment, Your Honor.
Give me, as soon as he comes out, I'll get the case called.
Thank you, Your Honor. I apologize,
You're
but
welcome, sir.
the way
I
it's set up,
apologize, Mr. Bowditch, we're almost done. It's not even 11 o'clock, even though Miss Bailey's yawning. It's still early in the day.
those little blue things that tell you can join are always blocked. I need to have my host put further down the list.
Oh, it looks like the court clerk Heather is in with him. He's out now. There we are. It's 22WM00854SM. This is State of Michigan versus Brian Johnson. May I have your appearances, please?
Your Honor, for the record, Your Honor, Jeffrey Bowditch, 45367, appearing on behalf of with Mr. Johnson.
And Michael Kizek for the people, Your Honor.
Your Honor, today, Mr. Johnson, would
Hold
you?
on 1 second. I'm sorry. Mr. Johnson, turn your video on and state your name for the record, please, sir.
Brian Johnson.
Thank you.
Your Honor, today is a date and time set for pretrial in this matter. I've spoken with prosecutor. There is a little information missing. We're requesting an adjournment in this matter.
How long of an adjournment are you looking for, sir?
Oh, I think the next available court date, Your Honor, would be fine for both parties.
August 10th at 10:15.
August 10th at 10:15 a.m. And that will be in number 3 by Zoom with Judge Green. Anything else on behalf of the people?
No, thank you very much, Your Honor.
Anything else on behalf of Mr. Johnson?
Nothing, Your Honor. And Mr. Johnson, Mr. Bitar will be with you on the 10th.
Okay, thank you.
Thank you, Mr. Johnson. You're all set, sir. Have a good afternoon.
You too.
Thank you. The 2 formal hearings are scheduled at 11 and 11:15. I have not seen defense counsel as of yet. The practice of this courtroom is 15 minutes after the scheduled start time, Ms. Bailey. So if they appear in the interim, Mariana will let me know. I'll come right back out. Otherwise, I'll take a brief recess.
Your Honor, I believe that completes my docket.
It does, Mr. Bowditch. Thank you for your assistance this morning in assisting with Mr. Jadala's and Mr. Bitar's cases.
Your Honor, always a pleasure.
Good morning, Mr. Calabat. How are you?
I'm doing well, thank you. How are you doing?
I'm well, thanks. Do you need to speak with the prosecutor before?
Yes.
Okay, all right. Ms. Bailey, are you there?
I think she's muted.
Yeah, I'm gonna put you in her meeting room.
Okay, perfect.
Okay, and Mr. McDermott, do you need to speak with the prosecutor?
Yes, I do.
Okay, I'll put you in her waiting room. Good morning, Mr. Chambers. Can you hear me?
Yes.
Hi. I see, oh, you're here for Christopher Wiley?
Correct.
Is he going to appear?
No, he's in Frank Murphy. I'm in Frank Murphy as well. He's in custody.
Oh, okay.
So he'd be having arraignment on the information before Judge Bridget Hathaway, and they brought him physically to the court. So he's in the bullpen right now.
Oh, okay. So are they gonna put him, are you requesting an adjournment or what?
I would ask probably for a continuance. I was gonna probably ask the court for a continuance anyway, because there's an outstanding discovery issue.
Okay. Prosecutor, do you want me to put you in a breakout room with Mr. Chambers?
Yes, so that'd be great. Thank you.
Okay, thank you.
Can I ask you a question to the clerk?
Yes.
I talked to the prosecutor, Ms. Bailey. We're gonna wait about 5 minutes and see if the cop shows. She said
Okay.
until like 11:10.
Okay, sounds good.
So-
Thank you. I'll let the judge know.
I appreciate that. Thank you. Sooner the better for me.
Okay.
Thank you.
Yep, you're welcome.
Okay.
Thank you.
Mr. McDermott, you look too serious for 11:08 in the morning.
Oh, I had to drive out to Granville this morning, Judge, so lots of construction.
No, do not miss the early mornings drive to Jackson and Battle Creek and Kalamazoo and all that other stuff.
Amen.
Have you been in with the prosecutor already?
Yeah, we're just waiting to see if the officer's gonna show.
Okay.
Same on my end, Your Honor. She said we can call it 11:10. Obviously, you make that final call, but the prosecutor was fine with 11:10. I have Yahya Al-Shari.
Mr. Calabat, she knows my time is 15 minutes, so if she says 10 minutes, it's 10 minutes. It doesn't matter. So
I
this
got
court,
you.
I'll call
I
it when
understand you make the
parties-
final call.
No,
I completely understand.
I'll
Thank
call
you.
it, no. I call it when the parties are ready. My practice is just for myself. It's nothing to do with you all.
Okay, yeah, she mentioned 11:10, but thank you.
Mm-mm. That's fine. I'm not gonna argue with you about 5 minutes. That's
Thank you. Thank you.
This is 2S4-034-842-SI. This is State of Michigan versus Yahya Al-Shari. Apologies on the name, but AL-SHAREY.
Okay.
May I have your appearances, please?
Dan Calvert appearing on behalf of Yahya Al-Shari.
Shari.
And Bryn Bailey on behalf of the people.
Thank you. Today is the day and time set for the formal hearing on this violation of basic speed law. The case was scheduled at 11 o'clock. It's now 11:10 a.m. Miss Bailey, do you have any information regarding the appearance of Jeffrey Little?
I do not, Your Honor. I don't see him in Your Honor's breakout room or in the waiting rooms, Your Honor. Without him, people will not be able to proceed.
And Your Honor, I make a motion to dismiss.
Motion to dismiss is granted. Anything else, Ms.
very
Bailey?
much.
No, Your Honor, nothing further from the people.
Thank you. Anything else, Mr. Calabat?
No, Your Honor, appreciate it. Thank you very much.
Thank you.
Have a good day. You too. Thanks, everybody.
Mr. Chambers,
Yes,
any update on Mr. Wiley?
he's in jail. He's in custody at Frank Murphy right now in a bullpen, Judge. I'm in Frank Murphy myself. He has an arraignment on information on another matter before Judge Bridget Hathaway.
This is 220455FY. Mr. Chambers, thanks for getting back on with us. Any objection, Ms. Bailey, to putting this matter over for a week?
None.
Judge, may I suggest two? And the reason I make this suggestion is there's a discovery issue.
Mr. Chambers, 2 weeks is fine.
Okay, thank you.
And Your Honor, I am
The
working on the discovery issue. I'm doing my very, very best. I have reached out both to the officer in charge and to his supervisors. My understanding is that it is a multiple jurisdiction task force involved in this particular incident. So there seems to be a little bit more hurdles that I'm trying to jump through to get Mr. Chambers his discovery, but I am working on it.
And Mr. Chambers, I cut you off. I thought you were down busy and Frank Murphy. Is 2 weeks going to be sufficient, or did you want more time?
No, I mean, 2 weeks should be, I would hope for it to be sufficient for the probable cause. I mean, situation at least to get discovery, I would hope. I doubt if I'll be able to review all the discovery by then because I'm expecting it to be a lot. I'm familiar with the case and at least what's on paper, and I'm expecting a lot, but we'll deal with it.
Okay, we'll put it over 2 weeks. That'll put us on August 3rd, 2022. It'll be back on Zoom in courtroom number 2 with Chief Judge Brian Oakley. Anything else, Ms. Bailey?
No, Your Honor, nothing further.
Anything else, Mr. Chambers?
No, Judge. And I guess just to inquire, that is going down as a continuance or a court adjournment and not a defense adjournment?
Correct, sir.
All right, thank you. I appreciate it. Have a good day.
You too. Thank you, sir.
Yep.
Gidry is scheduled at 11:15. Mr. McDermott, this court's practice is 15 minutes after the scheduled start time. I'm not sure if Carrie Clark, the officer, is, I don't see them present, but we'll wait a little bit to see if they appear.
Very good, Judge.
And then our first exam is 11:30 Bennett, I believe. If Miss Bailey is available. This is 2S4056700 SI. This is State of Michigan versus Douglas Guidry. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Sean McDermott on behalf of Mr. Gidry, P46101.
This matter is scheduled for a formal hearing at 11:15 this morning. It's now 11:27 by the court's clock. Are the people ready to proceed?
Your Honor, the people are not prepared to proceed. I do not see the officer or any trooper or officer here in the Zoom meeting room, Your Honor. Therefore, the people are not able to proceed.
Move to dismiss, Judge.
Defense motion to dismiss is granted. Thank you for your patience this morning, Mr. McDermott. Have a good day.
Thanks, Judge. Have a good day.
Our next thing is scheduled at 11:30. I think you said Brother Counsel is handling that exam, ma'am,
Yes, ma'am.
and there's nobody upstairs, so I will be in recess until the court receives indication that that case is ready. Thank you. I don't have any.
All right.
You may be seated. This is 220323 FY, State of Michigan versus Bennett. May I have your appearances, please?
Yes, good morning, Your Honor. He's at people P214.
And good afternoon, Your Honor. Luther Gillespie, 38683 on behalf of the here.
Thank you.
Orion Bennett.
Thank you very much. Today is the day and time set for the preliminary examination. In this matter, there is count one, malicious destruction of personal property, $1,000 to $20,000. Count two, assault with a dangerous weapon. Count three, assault with a dangerous weapon. Count four, malicious destruction of personal property, $200 to $1,000 misdemeanor. Reckless driving misdemeanor. Assault or assault and battery misdemeanor. Are the people ready to proceed, sir?
We are, Your Honor.
Defense ready to proceed, sir?
Yes, sir.
Any preliminary matters for the people?
Not for the people, thank you, Your Honor.
Any preliminary matters for the defendant?
Sequestration.
Sequestration order is granted. The officer in charge may remain in the courtroom during the pendency of these matters.
Thank you, Your Honor. The people, as the first witness, would like to call Ms. Latasha Bryant, LatashaBryan.
Good morning, ma'am. Come straight through those gates all the way up to this first podium for me, please. I'm going to have you state your first and last name and then spell it into the record.
Latasha Bryant, LatashaBryan.
Raise your right hand for me. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you much. Come up here, please. Have a seat in this first black chair. My secretary will be taking down your testimony this afternoon. If for some reason she's unable to hear you, I'll ask you to either raise your voice or pull that microphone closer, okay? There is a way. I thought on the side somewhere. Are you gonna be okay? Okay. Your witness, sir.
Thank you, Your Honor. And good morning, ma'am. I'm going to ask you a few questions about what happened on the 26th of April, 2022. Can you recall that date?
Yes.
And on that morning, were you at the Shell gas station on 11530 Belleville Road in the city of Van Buren Township?
Correct.
And can you describe what happened on that date? If it was an important thing.
You want me to just start from the point at the gas station?
When you were at the gas station, did you encounter anyone?
Yes.
And who was at the gas station?
First, I talked to Sequoia Jones. She approached my vehicle to get some things out of it. And I then got out of my car to talk to Miss Araya Bennett.
And now you see Miss Bennett in court today.
Yes.
And can you just point her out for the court, please, and describe what she's wearing?
The young lady in the green shirt, neon green shirt.
And you're on the record just reflecting what signifies Bennett, Miss Bennett.
Pardon me?
Yes, he was asking me to do something on my end. Sir, I'm going to stop you for a moment, and Mr. Glenn as well. Neither of you were here when this case was scheduled. We set this exam date back on June 1st, 2022. It was Ms. Bailey and Mr. Parker. There is no note in the file, but before we take any additional testimony or get any further involved in this case, I want to make a note for the record that I am married to an elected official in Van Buren Township. I make this disclosure as Van Buren Township is the issuing agency in this case. My husband would have no idea about this case, the facts of this case, that it was scheduled today. He has no daily interaction with the Public Safety Department. That being the case, are the people prepared to proceed?
Yes, Your Honor, we have no objection to the court hearing.
Mr. Glenn, are the defense prepared to proceed?
We're ready.
Thank you. You encountered Ms. Sequoia.
Yes, Sequoia Jones came to my car to start retrieving some things. And then I got out of my vehicle to speak with Miss Araya Bennett.
And while you're, if something happened while you're speaking with Ms. Bennett.
Well, there were things that happened prior to me speaking with her, which is why I got out to talk to her.
But did you eventually speak with Ms. Bennett?
Absolutely.
And would it be fair to say that you got in an argument with Ms. Bennett at that time?
Oh, well, I guess, yes, you could call it an argument.
And at some point, did you eventually get back to your vehicle?
I never made it back to my vehicle.
And what happened when you were walking back to your vehicle?
Miss Araya Bennett got out of her vehicle and asked me, what did I say? Because I said something as I was walking away from her car. And then she got out the car and asked me, what did I say?
And again, and physically what happened at that point?
At that point, I turned around and told her what I said, and then she spit in my face.
And after, when you spit in your face, how did you respond to that?
I then lunged at her.
And would it be fair to say that physical altercation ensued at that point?
Yes.
And how did that resolve itself?
Well, eventually, Sequoia Jones got in between us at some point and was able to push me back.
And did you eventually go back to your vehicle?
I was trying to, yes.
And what happened when you were on your way back?
Miss Bennett jumped in her vehicle and took off, jumping the curb. She hit a vehicle. Then she came back around to try to hit me.
And where were you at in the parking lot at that point?
I believe I was standing in front of my vehicle at one point, or either on the passenger side. What I assumed is that Miss Bennett was leaving the gas station. I didn't ever think that she was gonna do what she did. So no, I didn't right away get into my vehicle because.
And you say do what she did. What do you mean by that?
Pardon me?
You say do what she did. I wasn't aware.
Oh, as far as taking off and jumping curbs and hitting other vehicles and potentially harming everybody in the gas station parking lot.
And you said you were you said the front of your vehicle, would that be fair?
Yes, if I can remember correctly, I was either in front or in front on the passenger side.
And where did Miss Bennett, you said she jumped her, where did the vehicle go to?
Well, as she proceeded, she jumped the curb in the gas station and then hit a vehicle, like a red vehicle. And then Miss Bennett then bagged up and proceeded to come after me in her car.
Okay, and when you say come after you, were you still at the front passenger side at that point?
I was, but I assumed that she was done after hitting that car. I was like, okay, it's over, but no, it wasn't.
What did Miss Bennett do then?
She then backed up, put the vehicle in reverse, and proceeded to pursue me standing outside of my car, inside of her car.
And when you now did she drive? When you say pursue you, what do you mean by that?
I mean, she was trying to hit me with her vehicle.
And did she strike you at all with your vehicle?
No, she did not strike me, but when she struck my car jumped and hit me.
And where did she strike your vehicle at?
She struck my vehicle twice, once in the rear, and then as she proceeded to come around where I was standing to make I guess contact with me, she then hit the front passenger side of my vehicle.
Is that where the location where you were initially standing?
I then, once I saw she wasn't finished doing what she was, doing, I then stepped around to my driver's side of my car to get out the way.
And that's when she hit the passenger side.
Passenger front side.
And what's going through your mind when all this is occurring?
I was stunned. I don't even know if scared came out right away. I was definitely in fear for my life at that point because it just went left so quickly.
And where was your and after she struck you the passenger side of your vehicle, what did you do then?
I then, once I saw that she came to a halt, I then got into the driver's side of my car. I was going to proceed to drive off, right? I wasn't for sure if my car was going to move because of the way it was hit. Next thing I know, I'm looking down and I look up and she's coming at me with a baseball bat.
And now, can you describe her demeanor at that time? Miss Bennett's demeanor.
Enraged, out of control.
And are you in your vehicle at this time?
I'm still in my car.
And what did Miss Bennett do with the baseball bat?
She proceeded to bash my window, the windshield of the car.
And did she say anything when she's bashing the window?
Absolutely. I mean, I can't remember everything that she was saying, but it was a lot of, bees and homeless bees and she gonna F me up and just all kinds of, like she was gonna try to get me.
And are you still in your vehicle the entire time?
I stayed in the car. I even tried to avoid hitting her because once I realized my car would move, I then waited until she moved out of the way so I did not run her over. Still thinking about her well-being as well.
And so how many times would you say she hit your vehicle with a baseball bat?
She hit my car a total of 3 to 4 times.
And after you were able to move the vehicle away, what did you do? What did you do with that?
I was proceeding to leave the gas station and sit somewhere else just to remove myself from the situation. And here she come running up again with the bat as the lady of the first vehicle tried to approach me as I was leaving the gas station because she thought I hit her vehicle. So I was trying, while Miss Bennett is running up to me with the baseball bat, I told the lady, move because you're gonna get hurt. And she come and swing again and bust out 2 more windows out of my vehicle.
And that's Miss Bennett, is that right?
Yes, correct.
And are you still in your vehicle at that time?
I never left my vehicle until the police
And
came.
did the police eventually arrive at the scene?
Yes.
And did you tell the police what you described today regarding Miss Bennett hitting your vehicle and then they assaulted with a baseball bat?
I did, yes.
Thank you. Your Honor, I have no further questions.
Thank you. Mr. Glenn, your witness.
Okay.
Now, going back on to April 26th. What kind of day was it?
It was like 12:40. I think it was like 12, about 12, close to 1 o'clock in the morning, like 12:42, 12:46. Correct.
Okay. And this happened at the Shell gas station?
Correct.
Were there any other people in the parking lot while this was going on?
There was when it was going on, yes.
And let me rephrase the question. You and your vehicle were there.
Correct,
And you also mentioned that it was a lady by the name of Sequoia.
correct.
Now, were you and Sequoia in the same vehicle or did she got out of here?
No, Sequoia Jones is actually Araya Bennett's sister, and she was in Araya Bennett's car.
Okay, so she was with Ms. Bennett.
She was with Miss Bennett.
Now, you indicated that Sequoia came up to you first. to try
Yes.
to Get some clothes.
Absolutely.
Now, was this a prearranged meeting?
It was, yes.
Okay, when was this meeting prearranged?
It was arranged that night.
Okay, how much before, an hour, 2 hours?
About an hour.
Okay, who was supposed to be at the gas station? Or the arrangement, what was the arrangement?
The arrangement was for me to give her her things.
You say her, you talk about.
Sequoia Jones, correct.
And that was your intent?
Absolutely.
Okay. Now, when you got there, Sequoia came to your vehicle with the tree rod.
Correct.
Did you have all her items?
No, she was still gathering things out of my vehicle.
My question was, did you bring all Sequoia's items?
All of the
Yeah.
things that she had in my car.
Okay.
Mhm.
And was there a dispute about some of the items that you retrieved or anything like that?
No,
Now, you said there was a point in time where there was a argument or confrontation between you and Ms. Bennett, right?
correct.
All right, and at that point in time, you were still in your car, but Ms. Bennett left her car, approached you.
No.
Okay.
What happened is Sequoia Jones came to my vehicle to retrieve items. As she was retrieving her items, I got out of my vehicle and approached Miss Bennett.
Okay, now, why would you approach Ms. Bennett when the arrangement was for you to give Sequoia her clothes?
Okay, well, the reason for that is because prior to this whole gas station debacle, there was a prior situation between Miss Bennett, my son, and Miss Bennett kept calling me. Now,
Okay, let me stop there.
okay,
Okay, so that's what you were talking about earlier, about things that were going on before.
prior to this whole situation.
So nothing at the gas station started this conflict,
Not
this
at all.
situation before.
It absolutely was.
So would it be fair to say that you and Ms. Bennett weren't on the best terms?
No, I would not say that, which is the reason why I tried to speak with her, because there have been situations that have come up prior that me and Ms. Bennett and I were able to discuss level-headed. So at this point, I'm not thinking.
Now, is this
Mhm.
Bennett, motion for you to come to her or you just went to?
No, I went to talk to her
On your own?
on my own, and I was non-confrontational.
Okay, and how close did you get to Bennett before something happened?
As far as what do you mean, while she's still sitting in her car?
No, that's what I want to know. Did you get out of her car, spoke to you, or you just went all the way to her car?
Initially, I did walk up to her car
Okay, what happened?
and I was trying to talk to her.
Okay, now when you were trying to talk to her, was she the driver?
She was the driver.
Okay, you went to the driver's side,
Absolutely.
right up, close to the window?
Yeah,
Okay.
yes,
And her window's down?
yes.
Okay,
As far as I can recall, I don't know.
all right, and then that's when the dialogue began.
Correct.
And you said that, yes, somehow.
Correct.
And how much did it escalate from pleasant or a calm conversation?
Well, I honestly kept trying to calm the conversation down because she made several attempts to get out of her vehicle to fight me. And I kept continuing to tell Miss Bennett that I'm not going to fight you. This is not a fight. I just wanted to talk to her.
Now, when you said you made several attempts to get out of the car, were you forbidding her from opening the door?
No, I just kept trying to redirect her and let her know, I'm just trying to talk to you. I do not want to fight. I just kept trying to redirect the situation. And once I saw she said, like, if you don't want to fight, then get the F away from my car.
Okay, what did you do then?
I turned around, I said something back to her and I walked away.
Okay, what was the something you said?
I said, F you, you burnt piece of toast. As I was walking away.
And then you were walking back, that's when you, like, she said, what did you say?
Right, she then jumped out of her car and said, what did you say? And I told her again, and that's when she spit in my face.
And that's when the physical altercation.
And that's when, correct.
And were there any weapons at that point?
Not on my end, no.
Okay, well, I'm asking you, were there any weapons?
I can't say what she had.
Did you see it? Did she use it?
Eventually, she did.
I'm talking about at that point.
I can't say what she had, sir. I wasn't in the vehicle with her. I have no idea.
I'm talking about when she spit in your face and you threw a fight.
At that point, no, I didn't see anything.
That's my question. You didn't see anything.
I didn't see a weapon, as you
Did
asked.
you have a weapon?
No, I came there alone. I was just getting off work.
Okay. And the fight, how far did the rest before it stopped or you two were separate?
Okay, pardon me, say that one more time.
How long were you and this Bennett fighting before someone separated you?
I don't know. It probably was like 5-10 minutes, but yeah, I don't
Okay,
know.
so 1 month or period of time, and then I believe you said some sweat in between you two.
Correct.
Anyone else?
Well, the cousin in the passenger seat of Miss Bennett's car came out and around.
Do you know that person's name?
Her name is Diamond, that's all I know. I don't know her last name.
And did she try to stop the fight or separate you two?
No, she kind of just stood there. Mhm.
Okay, was there a point in time where you and Miss Bennett were separate?
There was.
Okay, what happened then?
Then Miss Bennett jumped in her vehicle and took off.
Now, where was her car?
Her car, I pulled up behind them at the gas station.
I don't know what the layout of the gas station. Were you by the pumps or were you by?
We were by the pumps.
Okay. And, do you know the number?
I do not.
Okay. Do you know how many pumps there were in the gas station?
I do not.
Okay.
There's a video.
There's a video?
There absolutely is a video
Okay, and how do you know there's a video?
because I saw it. It
Okay.
was
Who showed
people,
it? No, who showed it?
first, it was sent to me by, I believe, Sequoia Jones,
Okay.
which is Miss Araya Bennett's sister.
And you said that was the first time, was there a second time?
Absolutely.
So all right, so there were multiple times that you would send a video?
That I saw the video, yes.
Well, when you saw the video, were you emailed the video or you look at it on social media?
Yes, well, from my understanding that the young men who were there at the gas station that night.
Okay, I don't want to know about it.
I'm trying to answer your question,
No,
sir.
I understand.
Okay.
There's a reason to look at all. I just want to know, you have views of video, all right? And those were videos shot by private individuals or maybe a phone.
Correct, and I believe they put it on Instagram.
Okay. And did you see a video from maybe the gas station?
I did.
Okay, when was that?
That was after the detective called me and told me that it's on television.
Okay, you saw that video as well?
Yes, after I got a call from the detective.
Thank you. Any redirects, sir?
Just briefly, ma'am, you indicated, the defendant had hit your vehicle with her car, is that right?
Correct.
And what was and can you describe the extent of the damage you had to your vehicle as a result of Miss Bennett's actions?
The rear end of the passenger side vehicle was pushed in, dented on the wheel well, like it was scraping on the wheel at that point, and then the entire front end of my vehicle was pushed in from the passenger side over.
And did you ever get a assessment of how much it would cost to fix your vehicle?
It was more than what my car was worth. At that point, my car was worth 16,000, and my insurance completely totaled out the vehicle and paid my finance company.
I have no further questions, Your Honor.
Thank you. Ms. Bryant, thank you for your testimony this afternoon. You may step down.
Thank you. The people have no further witnesses this time, Your Honor.
Thank you. Any witnesses from the
No
defense?
witness for the defense, Your Honor.
Thank you.
And Your Honor, this time I would.
One moment,
Oh,
please.
I apologize.
No worries. Sir,
Oh, okay. This time, Your Honor, people would move to find over on the counts charged complaint and warrant. I think it meets the proper cause standard. This Bryant's testimony established that defendant did commit felonious assault against her both baseball bat and her motor vehicle, and also destroyed property in the value of $1,000, $20,000 that belonged to Miss Bryant. So on that basis, Your Honor, I would ask the court to find over on the charges.
thank you. Mr. Glenn.
Question of fact, or part of that.
Thank you, sir. Court has had the opportunity to hear from the witness this afternoon regarding the charges in this case, as well as arguments made by the attorneys. This court will find that the prosecution has made its probable cause standard, and Ms. Bennett will be bound over as charged to the Frank Murphy Hall of Justice. The next hearing date in this matter will be an arraignment on the information, which will be on August the 3rd, 2022 at 9 a.m. Her previously entered bond, Ms. Bennett's previously entered bond with any conditions will continue. Is there anything else on behalf of the people?
No, thank you very much, Your Honor.
Anything else, Mr. Glenn?
No, Your Honor, thank you.
Thank you. Ms. Bennett, this court is in recess, ma'am. Good luck to you.
Thank you.
Our next hearing is scheduled at 1:30 this afternoon. There's one person waiting to come into the courtroom. Let's see what they want. Sir, good afternoon. Your name, please? Back at 1:30. Yes, there's somebody, but we don't have anything scheduled. Sir,
Yo,
yes. Good afternoon.
good afternoon, man.
Your name, please.
Douglas Gidry.
Mr. Guidry, you had court at 11:15, sir. Your attorney appeared and your case was dismissed. Anything else?
Oh, no, that's fine. Thank you, man. I'm going on. Have a blessed day. You heard me?
You too. Bye-bye.
All right.
Not smoking in court,
I'm on the camera, actually.
but this is court, sir. It's recording and it's streaming live on YouTube with you having whatever that is dangling out of your mouth. Not a good look. Thank you.
All right. I'm going to smoke it later. You're going to have a blessed Oh, what fool. Oh, man. Oh,
Hi, Mr. Bicker. Can you hear me?
Yes, I can.
Hey, hi, how are you?
I'm fine. How are you doing?
I'm good, thank you. You're here for Wells Cadell?
Correct.
That, was adjourned until, 8:17 at 1:30.
Yeah, so I was informed by the prosecutor that she was going to make that request. So I had my client Zoom in instead of us up here in person.
Right.
Anticipating that would be the decision. So I didn't know we weren't going on the record though.
Yeah.
Okay. You
You're
said
all
eight.
set. And it
you said
looks like your, client is trying to connect, so.
Yes, he is, but I can give him a call if you want.
Okay, that's cool.
I'll give him a call.
All
All
right.
right.
Have a
Thank
good
you.
afternoon.
You said 8:17, right? At 10:30?
8:17 at 1:30.
At 1:30.
Yeah.
That's why I always ask again. Thank you.
All right, you're welcome. Bye.
Bye-bye.
that about your video. I did do a press. I know it. And I looked at it, I was in the right spot. Yeah, I remember that. This is a nice courthouse. I had a lot of time in the old one. I went way back to Judge Stone's days. Yeah. That's awesome. You got really. Yeah, that's made out of metal. It is? Yeah, it is. They had a machine that cut it out. Right. Right. Coming back, let's see things how we have on the docket. That's the last one. That's all right. District Court sound session now, will be some markers.
You may be seated. This is 210101 FT, State of Michigan versus Stephen Charles Poindexter. May I have your appearances, please?
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good afternoon, Your Honor. George Kelsey representing Stephen Poindexter. Mr. Poindexter is sitting next to me, Your Honor, and we are ready to proceed.
Mr. Poindexter, state your name for the record, please, sir.
Stephen Poindexter.
Thank you so very much. Today is the day and time set for the live preliminary examination. There is count one, police officer fleeing third degree. There's a misdemeanor failure to stop after collision, misdemeanor operating no license, multiple licenses. Are the people ready to proceed this
Your Honor,
afternoon?
the people are not prepared to proceed. Trooper Cross is not present here in the courthouse today. He is unavailable, and I have no explanation as to why. Without him, people cannot proceed to examination.
All right, move the court to dismiss the three cases. I discussed this with the prosecutor. I believe she will recommend they don't reauthorize. For the record, he does have a driver's license. He had one that I think the wallet was in the car. There was no damage to the police car, so there was no damages that we have to be concerned about. And he has paranoid schizophrenia. Has been diagnosed, and he's now in the care of his mother, who's in the courtroom. He now takes his medication by injection. It's good for 30 days. It's monitored by the Washington County Health Department. And so this was kind of a wake-up call. He wasn't taking his medication. He now has a job at Camaro's Pizza, and I think he's kind of turned his life around somewhat.
Thank you. Mr. Kelsey, I remember your client. We've had quite a number of hearings in this matter, and his mother has always been there to be supportive during those hearings. The defense motion to dismiss this case is granted. Anything else in this matter, Ms. Bailey?
No, Your Honor, nothing from the people.
Anything else, Mr. Kelsey?
I'm sorry, Your Honor?
Anything else?
No, nothing further, Your Honor.
Thank you.
I recognize you now.
Mr. Poindexter, good luck to you, sir. Have a good afternoon.
Thank you so much.
Thank you.
I go back to Judge Stone's case, and it was a nightmare to go to courthouse.
It looks, we've been here since last May, and it looks a lot different than the old building.
That's good.
Wait, you don't have any more? Is that what you said?
Oh, no, any orange ones.
Any orange
Orange
ones?
tiles. So-
I know, I thought that was weird.
So I'm not gonna complain, you know. It's a lighter day. Mr. Kazak was a super big help today.
He was. I'll see you at 2:00 is the story. Thank you.
Hi, Mr. Kearney, how are you?
Hello, how are you?
I'm fine, thank you.
Um,
What case are you here for?
I'm just here to observe. I think Miss Anderson has an exam at 2 o'clock.
Okay,
Yeah, so I'll be quiet. I'll turn my video off.
all right, wait, it's live.
Oh, you were streaming on YouTube. Oh, that's great. I can just watch there then.
Yep.
Sorry, I know you guys weren't streaming on YouTube for a while.
Oh,
So,
you're fine, you're cool.
all right, thank you. I'll log off then.
Okay, all right.
Oh, did you really?
You may be seated. They all know who I am. We don't do all that. So this would be a good day for the Kona truck, which I'm still advocating for every Wednesday, but that's a whole nother talk show. This is 220306 FY. This is State of Michigan versus Tierra LaShawn Faisal. May I have your appearances, please?
Good afternoon, Your Honor. Britt Bailey on behalf of the people, P84009.
And good afternoon, Your Honor. Neighborhood Defender Service by Lauren Anderson, P85191 on behalf of Tierra Faisal, who is not present.
Ms. Anderson, any explanation for your client's failure to appear this afternoon?
No, Judge, unfortunately, I have no representation.
Thank you, ma'am. Ms. Bailey.
Your Honor, at this time, the people would move for a KPS.
Again, today is the day and time set for the live preliminary examination. This matter was scheduled at 2 o'clock. It's now 2:27 p.m. by the court's clock. When this court scheduled the exam, that would have been on June 1st, 2022, defendant was present, heard the court give the day and time for the exam. Based on a failure to appear, bench warrant shall issue 5,010%. Anything else on behalf of the people?
No, Your Honor.
Anything else, Ms. Anderson?
No, ma'am.
Thank you so very much. That concludes this matter. Have a good afternoon. And I believe that concludes your docket as well, ma'am.
Ms. Mosisian has one at 2:30.
I'll see you in 5 weeks.
See you in 5 weeks, Judge.
Take care, Perkins.
Take care, Judge.
Yes, ma'am. Did you forget? You just didn't have yeah, I just saw Mr. Jablonski go by. She's playing with me. She's not ready. Oh.
Oh, no. I thought it was-
I'll have the prosecutor say when we get off the record.
Very nice flowers.
Local place, flowers in the
You
mitten.
can even smell it.
As soon as you open the door. Yeah.
Wow.
Well,
Is it your birthday?
No, the problem is, I don't know what you see, but all I see is behind me and all this expansive black. So she's right downtown. She has a subscription. So I signed up for a subscription service. Once a month, there'll be flowers, and her flower seems to last about 2 weeks.
Wow.
So then when I'm sitting here and I'm looking, I can see that,
Aw.
because I've seen Lady Justice, she and I have been together now for about 10 years, so we needed something different.
I like it. It like you can immediately see it because generally you don't see flowers in a courtroom, so it like makes it a lot friendlier.
Well, everything else up here is short, so there's stuff behind
Yeah.
with me, but you can't see it from out there. Okay, listen, you. Is he walking all close? Aren't you supposed to be protecting me? He just lets people willy-nilly come walking up here. Somebody came up here, handed me stuff, I'm sorry.
You're no better.
If that's why I have a pile of rocks up here just in case. Anyway, this is 220400 FY. This is State of Michigan versus Robert Tyrone Riley Harrison. May I have your appearances, please?
Good afternoon, Your Honor. Sona Mosisian on behalf of the people, P83923.
And good afternoon, Your Honor. Brendan Dvorsky appearing on behalf of Robert Riley Harrison, who's standing to my right. Mr. Riley Harrison, state your name, for the record, sir.
Robert Riley Harrison.
Thank you. Today is the day and time set for the in-person preliminary examination. There is count one, assault with dangerous weapon, count two, malicious destruction of personal property less than $200, that's the misdemeanor. And count three, domestic violence, again, a misdemeanor. Are the people ready to proceed?
Judge, the people are not. I have spoken with the complainant, Chanel Davis. She was aware of the date and time of today's preliminary exam. She indicated to me that she no longer wishes to cooperate, and the people are unable to move forward without her testimony.
Your Honor, with that said, we were prepared to proceed this afternoon, but that being said, I would ask this to be dismissed.
Inasmuch as the prosecutor has made representations that the complainant no longer wishes to participate and cooperate in these proceedings, the defense motion to dismiss is hereby granted. It appears that Mr. Riley Harrison's bond was 5,000, 10% personal. I'm sorry, not 5,000, 10%, 5,000 personal. There's nothing else to do on this matter. Dismissed without prejudice. Anything else on behalf of the people?
No, thank you.
Anything else, Mr. Dubowski? Thank you. Good to see you. Good luck, sir. Have a good afternoon. Thank you. Okay. Hey, were we gonna talk to Sona?